Hello everyone, very good afternoon. Welcome to StudyIQ IS English channel. I am your educator Praveen Mishra and we are going to proceed with today's marathon session of the current affairs. So as prelims is approaching very quick and fast, it's just less than 1.5 months what we can call it in general. So we need to mug up with the current affairs as much as fast we can and as much as in depth we can go ahead. And for that sake, we are going ahead with today's marathon session. Okay, we will be covering about the polity and governance issues for the month of February 2025. Right, everyone? So let's begin up with the first ever topic for the day. And please do let me know if there is anything into the comment section so that I can eliminate the doubt immediately. Right? So starting with the first topic for the day. That is the first topic for the February 2025 is with regard to the institution known as Panchayats or the Panchayati Raj, right? Democracy, it can be strengthened when it is accessible to all the masses, to all the sections, all the classes, all the particular communities. Call it from the urban societies, call it from the rural. So for that sake, democracy has established itself from the grassroots towards the apex level. And the grassroots level of democracy is considered as the most strongest level of democracy in order to redress the grievances of the rural masses. And for that sake, we have established the panchayats in our constitution as well through the 73rd Constitutional Amendment Act of 1992. So when we talk about the issue here, the whole context, in present days, big shifts in both technology and society are threatening to make panchayats irrelevant. Well, if someone will ask me about my personal opinion over this thing, that do you actually agree with this? So this is once again, I'm talking about my personal opinion. It could differ. You might be having the same, could not be as well on the same side, right? So do you think that the advancement in the growth and development of the technology, information technology specifically, is threatening the relevancy of panchayats? Well, I don't think so. But yes, there are some aspects that we need to cover from this from the perspective of the statement. And what is the perspective here? So, introduction of Panchayati Raj system in India, as we have already discussed, that is 73rd Amendment Act 1992, everything was given. Okay. The only concern here is technology hampering the growth and development of panchayats? Well, to answer it, the correct answer will be no, absolutely not. And what is the reason? Reason is here that technology, when used in its actual sense, in its actual essence, provides a boost in the growth and development of an individual. It provides you a greater horizons of understanding, not just the local issues, not just the domestic issues, but as well as the international issues. Simply speaking, it provides you something that is known as awareness. And this awareness program, in this awareness thing, we can understand that yes, I am now encountering all of those things that were existing previously, but possibly it was not in my notice. Right? So the whole scenario that touches here, firstly with regard to the key features of the 73rd Amendment that we need to discuss before proceeding. Okay, a three-tier system, that is panchayat is the third level of the democracy, no doubt in that. But in that third level of the democracy, it is also divided in three different organs, or the three different stratas are there. What are these? The Gram Panchayat, that is at the village level. Okay, then we have got the Panchayat Samiti at the block level, and we have got the Zilla Parishad at the district level. Right? So all of these things are the three levels, and regular elections, they do take place, that is in every 5 years. And apart from that, there is also scope of reservation of seats for SCs, STs as well as women. And apart from that, according to Schedule 11 of the Indian Constitution, right, panchayats have been entrusted with 29 indifferent functions or the responsibilities, such as, for example, agriculture, education, health, rural development, etc., etc. Right? Now, the news, the success of the panchayat. Where it depends, the success of panchayat, it depends on where? Obviously, in massive political participation. Simply speaking, in massive participation of the masses. Wherever the masses, they have participated collectively, that particular event has been registered in the list of success, right? Like, for example, the Quit India movement of 1942, though started by M.K. Gandhi, but it was led by not just one individual. It was led by each and every individual involved in that movement. And that's why what we have seen, Quit India movement was the biggest blow against the British Raj. If we go 90 years back from the Quit India movement towards the 1857, that is the revolt of 1857, what was the biggest failure of the revolt? What was the reason, the element that converted the revolt into a failure? It was less people's participation, or not, it was not a mass revolt, right? So Panchayati Raj has been considered as a successful event. The reason is the massive participation, political as well as social. And apart from that, the next thing, women empowerment. Around 14 lakh elected women representative, that is nearly 50% are now part of the local governance, ensuring gender inclusivity. We know it very well that how patriarchy has troubled our collective growth. See, call it patriarchy, call it anything that favors a section of the society. Obviously, it is a cancer to the whole group of people, to the whole community as a whole simply. So we know it very well that we need to eliminate this cancer. Cancer can be eliminated through a process in medical science that is known as chemotherapy, right? But do we have any chemotherapy to eliminate any such type of social evils? Yes, it is there. One such is known as education, and another such is known as women empowerment. And this women empowerment is absolutely visible with this data. 14 lakh active participant women are there into the panchayats. Simply speaking, data in percentage wise, 50% of them, they are here, right? And apart from that, strengthening of the local leadership. Many grassroots leaders emerging from PRIs have moved on to higher political offices at the state as well as national levels. So it is a statement that is directing towards a particular thing or a particular issue that explains, simply it explains that the leadership starts from the grassroots level, and a strong leader can be seen at the national and the state levels as well. And this is what is the perfect example, the PRIs. Apart from that, the very next thing, improvement in service deliveries. Areas with strong PRIs have witnessed better implementation of rural development projects related to roads, water supply, as well as public health. Like, for example, the state of Madhya Pradesh, or the state of Maharashtra, or in fact the state of Gujarat. These are some particular states which have performed exceptionally well in the rural areas. The civic supplies are there, the medical supplies are there, good schools are, we have seen, there is a particular event when we have seen that the schools in the village areas or the rural areas, they are performing well as well. Enrollment of the students are on a good time high. And apart from that, yes, the quality delivery of education is also being monitored. So all of these things are accredited to the PRIs, that is Panchayati Raj institutions only. So this is where the success comes in. And apart from that, the very next thing, okay, that PRIs, they have performed an exceptional task in providing impetus to India at the global level. Yes, you heard it correct. PRIs in the rural areas, they are being monitored not just nationally but internationally as well. So talking about any international financial institution or the non-financial institution as well, when they do provide their reports specifically from the perspective of India, like for example, the Human Development Index, the Human Happiness Index, etc., they do take care of the performance of the panchayats and the municipalities in the rural and the urban areas as well. And when they see good quality delivery of the civic supplies or as well as the education and medicinal supplies, then it literally provides us good marks, some good measures when it comes to the ranking of the nations. As we have seen recently that India's ranking has improved in multiple parameters, though not in the development index, though not in the happiness index, but yes, in other index it has improved. And the credit, one of the credit also is to be credited with the PRIs, right? Okay, so this is all with the first event, that is the first issue, that is the PRIs. Moving on to the next one, that is here, The social justice for Muslims should not be just about reservations. The second topic for the day. What is the context? The headline what we have seen, social justice for Muslims should not be just about reservations. Okay, no problem in that. But what is actually the context? What is the context here? The idea that reservation for Muslims is bad and affirmative action for Muslim is necessary may seem contradictory. First of all, let's just understand this concept of reservation. This reservation is majority of the times being mistaken. Okay, it is majority of the times taken as that it is just a support system. No, it is beyond that. It is not just a support system. It is beyond that. Let's understand it. So when we simply talk about reservation, reservation is itself a discrimination. Yes, it is. Reservation is itself something that is discriminatory. Not just to those who are not getting this reservation, but also to those who are getting this reservation. But this discrimination is considered affirmative. This reservation is considered what? Affirmative discrimination. It is not to degrade someone, but this is for the sake of upgrading someone. Okay. So let's say, for example, this is the general category of Indians and this is the non-general category of Indians. Now, I have to eliminate this line. This strata I have to eliminate. I do not want any individual to be considered as scheduled or suppressed or something like that. So I have to put this line here into the mainstream line. So what I can do? The best possible solution that was in front of the constitution makers was a ladder named as reservation. So they provided this ladder and this ladder came to be known as reservation, through which the marginalized people could climb up, okay, and could convert themselves into the mainstream society line as well, right? So as I stated, it is discrimination, yes, but it is affirmative in nature. No doubt it is discriminatory, but it is positive in nature. It is on the positive lines. Right. So this is what the concept here is. As we talk about Muslims in India, see, the Muslims, they hold a strong position in India. It's not like that they are suppressed or they are still under too much of the pressure or something as any kind of subjugation. Yes, there are instances, but these instances are against everyone. Call it Hindus, Muslims, Sikhs, Christians, Parsis, Buddhists, Jains, or whatever. Discrimination exists in the society. It exists not just in your society, not just in my society, not just in the Indian society, but in the whole of the globe. Discrimination is there, no doubt in that, right? But we have to eliminate this discrimination, and this discrimination will be eliminated gradually only. This is the thing which is considered as a gradual process, right? So this gradual process obviously will take time. And in India, when you talk about Muslims in India, around 30 crores of the population, a good chunk of the population, right? We live in harmony. Yes, there are issues when the harmony is disturbed. With recent cases, we have seen a lot of them, n number of them, in fact. But yes, the concern here is to upgrade a society, to upgrade a community. So in order to upgrade a community, do I have just one particular logic available with me, just one particular remedy available with me, that is reservation? No. If I just stuck to just one particular remedy, that means I am being ignorant of the fact that there could be other possible horizons, other possible chances as well. So this is what the whole story is. Okay, the idea that reservation for Muslims is a bad idea and affirmative actions for Muslim is necessary may seem contradictory. What could be the possible affirmative actions? So let's see that. The contradiction arises from a limited imagination of social justice, where affirmative action is equated solely with the reservation in government jobs and education. And apart from that, social justice debates in India are often reduced to battles over quotas, leading to multiple communities demanding reservations, including ex-servicemen, sexual minorities, and displaced persons, right? So, what could be the possible chances? There is a very wonderful saying, and we must stick to it. We must follow this principle at any cost. And that is what is known as education. I need to upgrade my education system. Education from the lower kindergarten to the PhD level. I need to upgrade it as early as possible and as much as I can, so that it eliminates all sort of discrimination, subjugation, and so on, right? So education, it is very widely stated as well, very greatly stated as well. Education is the only key through which a society can be renewed, a society can be saved, a society can be upgraded as well, right? So the whole scenario that is cutting down the whole story, the long story, into the short one, is that we need just to act in affirmative way, not just with reservation, but with as much as other possible scopes, as much as other possible elements. So for that, the demand for reservation for Muslims has intensified since the Sachar Committee report in 2006. There was a report. The report's name was Sachar Committee report. When it came in the year 2006, which highlighted severe educational and economic disadvantages faced by Muslims, categorizing them as a socio-religious group. Though the Sachar Committee report did not recommend reservations, it set the stage for subsequent demands. Remember this thing, guys. It could be a possible question in your prelims. Did Sachar Committee report provided any sort of, literally any sort of reservation element inside the report? No reservation measure for the Muslims was recommended by the Sachar Committee report. Though it is stated that the community is educationally quite backward. They are facing a huge level of disadvantagement, just because could be the lack of proper leadership or lack of the proper resources, availability of the resources could be. But yes, they provided the stage for the subsequent demands, but not they recommended any sort of measures for the Muslims. Okay, what is the name of the report? Sachar Committee report, year 2006. And see the next thing here. In 2007, the National Commission for Linguistic and Religious Minorities suggested a 15% quota for minorities with 10% specifically for Muslims in jobs and educations. Now, this leads us to discuss this one very important thing. How many type of minorities are identified by the Constitution of India? Come on, guys, any answer with this? What do you think? How many types of minorities are identified by the Constitution of India? Any idea? Come on, quickly. So to answer this, if this is the question, so the answer is quite simple, 2 types. And what are these 2 types? A religious minority, and the second one, it is not based on caste, community, or anything. It is based on simply language, that is linguistic minority. Only and only 2 types of minorities are identified by the Constitution. Make this thing very clear in your mind. One is based on religion, another one is based on language. And when you talk about the linguistic minorities, okay, so for that we have especially got Article 350 capital B inserted through the 7th Constitutional Amendment Act of 1956. That is a special officer for linguistic minorities. Okay, what is the concept? Special officer for linguistic minorities. Under which article? Under Article 356 capital B. 350 capital B. Okay, a special officer has been created as well. But this is just for the sake of linguistic minorities. We're not talking about the other minorities. And here, when we talk about this report, that is the National Commission for Linguistic and Religious Minorities, what it has stated, a 15% of a different quota, and out in the not just in the into the educational sector, but also into the jobs. And out of those 15%, 10% should be specifically for Muslims. Why so? This has been supported by various Muslim leaders and intellectuals amid rising socio-political challenges. Right. So do they need it? Do they really need it? Yes, they do really need it. Okay, when we see that is how much equally they are represented inside Lok Sabha, inside Rajya Sabha, inside the whole government, inside the legislative assemblies of the states, inside the panchayats and the municipalities. So we can see the data is not so satisfactory. It is in fact heartbreaking. So the point is, we do support such a committee report, and we do also need to support the National Commission for Linguistic and Religious Minorities report of 2007, right? So next topic for the day, the judicial backlog in India. What is backlog? Obviously, when you have too much of the pending work, that is known as judicial backlog, right? When I have got too much of the pending task with me. So how can judiciary have a backlog? Yes, judiciary has the biggest amount of backlog in India. Biggest amount. More than 2 crore cases are said to be pending inside the Indian judiciary, from apex court, that is Supreme Court, to high courts, to the subordinate courts. Reasons are multiple. And the biggest reason that I would like to highlight here is, it's like I'm not being I'm not criticizing this, but yes, I'm just highlighting the issues that are needed to be redressed as early as possible. A report from the perspective of judiciary was published in the year 2023, in the beginning of the year 2023, that is a couple of years back, 2 years back simply, which highlighted a very big trouble. You know how many days on an average the Supreme Court and high courts in India, they do work? Any rough idea you can have out of 365 days? How many days our judiciary, they do actively work? The data is once again really heartbreaking. It's breathtaking, heartbreaking once again. Out of 365 days, on an average, 200 to 225 days, average, 200 minimum to 225 days, the courts in India, they do work. Specifically speaking about Supreme Court and high courts in the states. So more than around 150 days of vacations are there every single year. With a population of 1.45 billion, with n number of issues, with n number of crimes, with n number of social discriminations, we need not just 365 days, we need more than that for our judiciary to work. It's not criticism, it's an issue that needs to be addressed. This particular concept of vacation has come from the British era, from the British Raj, when there used to be the European judges, those who used to travel all far across from Europe to India. And they do needed vacations, summer vacations, winter vacations, etc., etc. And at that time, this vacation concept was introduced inside the judicial system. But post-independence, we do not have any European judges inside our country. We do have got our indigenous, that is Indian judges only. Now, here shouldn't be any such thing that is known as summer vacations or winter vacations. Okay, it should be there, but it should be for a smaller amount of time, not for a month or a week, something like that. Okay, during Diwali, during Ramzan, during Holi, during Eid, during Bakrid, during Christmas, every one of us, we do deserve holidays. Yes, it's our natural right, it's our human right. But when I know that I possess a very strong position, a position that is very vital for the welfare state of every nation, then I must understand here that my vacations should not hamper the justice delivery mechanism of this nation, of this society. So the point is, this is an issue which is ignored since the 75 years of independence, but it won't be for a longer period of time, as we can easily watch this, that judiciary is inside the zone of a paradigm shift. They are now playing from the front foot. Yes, issues are still there. I'm not saying that every issue has been solved. No, it's not, absolutely not like that. But yes, the judiciary is evolving at a very greater speed, in a very swift speed, what we can simply say. So all of these issues will be very easily eliminated in a very short span of time. But let's wait and watch how much this short span of time would be. What will be the period of this time? Okay. So coming to the point here, the context. India's judicial system faces a significant challenge due to an enormous backlog of the cases. The issue affects all levels of the judiciary, from the Supreme Court down to the lower courts. And what is the whole news? As you can see, the heartbreaking data, the breathtaking data, the fact. Supreme Court, as of December 2024, Supreme Court it is, right, had a pending case of nearly 83,000. 83,000 cases are pending inside our Supreme Court. You know how many judges we have right now in our court? Just 34. 33 judges plus one Chief Justice of India. And think about the workload our honorable judges would be having. 34 of them and 83,000 pending cases, right? How are we going to deal with this? The other one is more disturbing. It's really disturbing. High courts, more than 62 lakh cases, 6.2 million cases. This is the data of January 20, 2025 itself. Means if Supreme Court is 83,000 pending cases, then High Court 62 lakhs. Now let's see the other side of the picture. Lower courts, approximately 5 crores. 50 million cases are pending. How are we going to have a proper good social fabric with such type of data? Don't you think so? It's now the time for us to have a change. Yes, it is time for us to have a change. And it's not like that judiciary, it is sitting mute and deaf. No, our judiciary is performing efficiently. And yes, sufficient actions are also being taken up by the judiciary to eliminate such type of data. But yes, also, it's not like that, you do not have some infinity stones and a gauntlet in your hand, in your fist, that you will just have a blip and all of the issues will be wiped out simply. No, absolutely not like that. It's a gradual process. Obviously, it's a time-taking process, and let's wait. Okay, it will take time. But yes, this will be eliminated for sure. Then, moving on to the further of the issue in the very same topic. Challenges in the judicial system. As I stated, just 34 judges for the whole of the nation in the Supreme Court. So low judge to population ratio. So what is the data? Only about 21 judges per million citizens, right? Million, that is 10 lakhs. For 10 lakh judges, 10 lakh people, I have got how many? Just 21 judges. Next. Adversarial legal system. Cases undergo multiple interim applications and appeals, prolonging litigation. You can appeal back to back, back to back, back to back. And this back to back appeal is obviously something which was created for the convenience of the masses. But now this convenience thing is only the adversarial thing. Next, shortage of resources. The biggest trouble. We need to enhance the budget of the judiciary, first of all. So infrastructure deficits, that is the courtrooms, they are less. The digital systems, they are even not introduced throughout the courts of the nation. Then apart from that, financial limitations, limited budget for the expanding judicial capacity. And last thing, high government litigation. That is, the government is a party in nearly 50% of the cases. That means 50 million cases in the subordinate courts, simply 5 crore cases in the subordinate courts, 62 lakh cases into the high courts, and 83,000 cases into the Supreme Court. So roughly we can say 5,63,000 cases are pending inside the courts in India. Okay, 5,63,000. Okay, and 50% of, 5 crore 63 lakhs. Sorry, my bad. Okay, 5 crore 63 lakh cases are pending inside the courts of India. And according to the data, 50% of the cases, government is a party. So nearly 2 crore 75 lakh, more than 2 crore 75 lakhs, or almost we can say 3 crore cases is up against either the government or by the government. And the government, not just the central government, it is also the state governments, it is also the local self-governments, call it panchayats as well as municipalities. So rest 3 crore cases that are against the humans, the normal humans. But the other 3 crore cases are alone from the government side. Could be against the government, okay? Could be by the government, okay? So, yeah, massive number, breathtaking number, right? So, what is the remedy, immediate remedy we can have? The immediate remedy is mediation. Mediation could be a very key solution. That is, rather than fighting a case inside the courtroom, let's have an amicable settlement outside the court. And what is the logic here? Mediation as a key. So what is mediation basically? It is a process where disrupting parties meet with a neutral mediator to find a mutually acceptable resolution. Okay. Confidential, flexible, and voluntary with no imposed decisions. Right? This is what simply the mediation is. Okay. And evolution of mediation in India. When you talk about, has it evolved? Yes. Mediation policy has evolved a lot. In 1990s, it was introduced in India as an experimental dispute resolution mechanism. By 2005, it began gaining traction in courts and becoming an accepted practice. And at present, judges frequently recommend mediation when it comes to the cases of property dispute. Simply, it's not for the severe crimes like murder, rape, and so on. No. Issues like related to like civil issues, like for example, marriages and divorce, transfer of property, acquisition of property. Okay, cases like that. Or then in such particular events, judges, they only frequently recommend what? Mediation. Apart from that, thousands of lawyers have become mediators. And lastly, courts recognize it as a viable dispute resolution mechanism. So mediation, it could be the very vital key, a vital element in order to just save our judiciary from becoming overburdened. Well, judiciary has already become overburdened. So this overburdening thing could be eliminated with mediation. Okay. Now, moving on to the next topic, to the next highlight of the story of the day. That is appointment of election commissioners. Democracy, the biggest soul of democracy. Well, it is a very debatable thing, to be very honest. What is the soul of democracy? So, as humans or animals or as a living creature, We do have only one soul, right? Atma, simply. Ruh, right? Spirit, whatever the name is. But for democracy, when it comes to the soul of democracy, there is a big conflict between political scientists that what is actually the soul of democracy, right? So some people, some scientists actually, soul of democracy. So many of the times you will see that fundamental rights, they are considered as the soul of democracy. Some suggest it as the participation of the people. So some also call it as the presence of justice inside democracy. And then some also call it as the election commission or the election mechanism. To be very honest, in my opinion, I will say, democracy has got all of these four things or beyond these four things as well as its soul. Because democracy is not a living thing. Democracy is a principle, it's a policy, it's a thought, it's an idea of creating a welfare state, of creating utopia. Yes, that's the logic as well. So, democracy, when we talk about simply, democracy has not just got one single soul. Democracy has got multiple souls. And one of them is the election mechanism, or simply speaking, the election commission. And the soul of election commission is the impartial, non-biased, transparent, answerable election commissioners, right? And now talking about the whole news. Context. The appointment process of election commissioners, that is the ECs, make no mistake guys, we are talking about election commissioners, not chief election commissioner. Okay, we are not dealing with the CEC. We are dealing with the other election commissioners, right? So the appointment process of election commissioners has been questioned for years, raising serious concerns about the autonomy and impartiality of this vital institution. Okay, so what is the whole journey we need to go through? Okay, first thing, the process of appointment of election commissioners. The previous law as well as the new law, we will be discussing all of them, right? So appointment process, the old procedure. Okay, guys, please be very clear while making your notes. I'm sure you guys are making your notes as well. Okay, so the old procedure, what was the old procedure? Appointed by the president on the advice of the Union Council of Ministers, usually suggested by the law minister as well as the prime minister. But things changed through the Anup Barawal versus Union of India case 2023. And what happened? SC ordered that the chief election commissioner and election commissioners, they shall be appointed on the advice of a committee. And the committee shall comprise of whom? The committee shall be comprised of the Prime Minister, then the leader of the opposition in the Lok Sabha, and the Chief Justice of India. So this is what the outcome is from the Anup Barawal versus Union of India case 2023. Okay, this is the order or the judgment given by Honorable Supreme Court of India. Okay, and what is the order? That is the chief election commissioner as well as the other election commissioners. They shall be appointed by whom? They shall be appointed on the advice of a committee, obviously by the president, but the president should be taking consultation. That consultation should be binding on the president, okay, by a committee. And the committee shall comprise of at least 3 people. These 3 people are the Prime Minister, the incumbent Prime Minister of India, and whosoever is the leader of opposition. Where? Leader of opposition. Leader of opposition in the Lok Sabha only, not the Rajya Sabha. And apart from that, the third person, it should be the Chief Justice of India. Okay, and now the new law. Appointed by the president based on the recommendation of a selection committee. And the selection committee is comprising of how many people? Comprising the Prime Minister a union cabinet minister, and the leader of opposition or the leader of the largest opposition party in the Lok Sabha in case there is no party which has secured at least 10% of the seats, right? So this is what the new law is. Next thing, selection committee. In the old procedure, it was not specified. In the case of Anup Baranwal, Supreme Court opined this thing. That is once again Prime Minister, Leader of Opposition in the Lok Sabha, as well as the Chief Justice of India. And what is the new law saying? Includes the Prime Minister, Union Cabinet Minister, Leader of Opposition, or the leader of the largest party of in the Lok Sabha. Okay, this is what the new law is. Now, search committee. It was not specified in the older law, and the new law what it says. A search committee would be led by the cabinet secretary that will recommend a panel of names to the selection committee. Okay. Search committee as in identifying the proper talent. In every company, for example, there is a HR team or the talent acquisition team. This talent acquisition team shortlists the candidates, some capable candidates. And then these capable candidates' names are sent to the further managers, those who take a short test or could be an interview or something like that. And after qualifying, let's say, for example, the talent acquisition or the HR team has recommended 10 candidates, right? And out of those 10 candidates, 5 have qualified the test or the interview by the managers, right? So those 5 will be selected. So here, a search committee, that is simply the talent acquisition or the HR team, will be shortlisting the names of the candidates, and this search committee will give the shortlisted names to the proper committee that will be having these names. Okay. Next, the salary and conditions. So here in the old procedure, equivalent to a judge of the Supreme Court, and in the new procedure, made equivalent to that of the cabinet secretary. So guys, please make it clear. This distinction should be very clear. Okay, in the older one, it was the judge of a Supreme Court. Salaries and allowances used to be equivalent to the judge of the Supreme Court. But according to the new law, it is equivalent to that of the cabinet secretary, right? Next, removal process. The CEC could be removed in a manner similar to a Supreme Court judge. Okay, but according to the new law, it retains the constitutional provision for CEC, that is removal like a Supreme Court judge, okay, only. That is, it remains same, equivalent. That is, for example, if I have to remove a Supreme Court judge, then firstly, I will have to provide a proposal inside the parliament, only and only inside the union parliament. It's not possible outside parliament in any state legislative assembly or whatsoever. If the proposal is to be done in the Lok Sabha, then I need at least the sign of 100 members. In case it is done in Rajya Sabha, then 50 members. The proposal will be admitted or rejected, will lie absolutely into the discretion of Speaker in case of Lok Sabha or the chairperson in case of Rajya Sabha. Then with special majority, that is 2/3 of the members present and voting, the removal procedure, the removal resolution should be passed, and from both the houses. And in that meantime, an inquiry committee is to be constituted as well, with the judge, Chief Justice of India, Chief Justice of a High Court, and an eminent jurist inside that. Okay, and then only after the committee has provided the proper report that the yes, charges framed on the concerned judge is valid, then only the resolution process will continue. Or else, if the committee disregard the charges, okay, then the resolution process will end immediately there, right? And if all of these things are happening on a simpler note, that is, the committee has created that, the committee has confirmed the charges, that yes, the charges are correct, the Lok Sabha has passed the resolution, the Rajya Sabha has passed the resolution, and then it will be sent to the president, and the president has also signed the resolution, then only the judge will be said to be removed. Okay, so it's a very long and hectic process, and it should all take place in one single session of the parliament. If the resolution is going on and the parliament session has ended, then the removal resolution will also lapse. Okay, so it's a very long, hectic process to remove a judge, Supreme Court judge or a High Court judge, and in the very same way, the CEC or the election commissioners, not election commissioners, sorry, CECs, they are being, CEC is being removed. Okay. So though other election commissioners, they are still on the pleasure of the president, basically speaking. Okay. But yes, the chief election commissioner is someone who cannot be removed very easily. So to safeguard the essence of democracy, such procedures are created. Okay. So this is a basic distinction or the differentiation between the older procedure and the new procedure. As you can see, everything has changed. Just one thing has remained constant, that is same, that is the removal procedure. Okay. So the next point, challenges in the appointment process of election commissioners. What are the challenges that are faced by the appointment committees? Okay, first thing, lack of institutional independence. Something that you must avoid. How come this be possible? Lack of institutional independence. This explains that how the interference is still existing. The world is not ideal. It's more realistic in nature, right? So this is what is written. The executive dominates the selection panel, affecting the neutrality of the ECI. Yes. And the 2023 Act replaced the Chief Justice of India with the Union Minister, giving the ruling party greater control. Earlier, there used to be a judge, but the 2023 Act removed or replaced the judge with the Union Minister. And obviously, the Union Ministers, they do come from the ruling party. Though not a rule, but yes, a convention for sure. Next, the new law overturned the spirit of ruling, leading to concerns over executive overreach. And apart from that, the next thing, delay in judicial review. Despite the ADR's legal challenge, ADR as in it is a not-for-profit organization known as Association of Democratic Reforms. This is also highlighted in the very upcoming next independent issue as well for the day. So we'll be discussing about the concept of ADR as well. Okay. So as we can see, the hearing on February 19, 2025 was adjourned without a new date, leaving uncertainty over the legitimacy of the appointments. It was adjourned. It was adjournment sine die. That means when will they have the next sitting? It was not even decided when the meeting was adjourned. The next thing, lack of transparency. The current selection process lacks public scrutiny and institutional checks as well. And lastly, but not the least, no parliamentary oversight or independent review mechanism exists. So this creates a ruckus inside the independence and the working roles and responsibilities of the Election Commission. Are they impartial? Are they absolutely transparent? Are they not biased? These are the questions which is raised every now and then because of, firstly, this procedure, and secondly, these challenges, right? Okay, so moving on to the next topic for the day. Here we go. The RTI is now the right to deny information. Sarcasm at its peak, right? See, satire or humor is good when it comes to have a good time pass. But when the satire and humor enters the political domain, it troubles the social fabric. It creates big ripples, big troubles with the concept of equality and harmony. And yes, also with the working procedure of the legislature as well as executive and the judiciary as well. So, the satire and irony and sarcasm, humor should be as much as possible be avoided when it comes to the discussion of the political and the social topics. But unfortunately, it is here. Okay. The right to information, it has become now right to deny information. Possibly 2018, if I'm not wrong, 2018 or 2019. The RTI Act was amended. Section 13 and Section 16 of the Right to Information Act was amended, which provided absolute power or authority to the government, central government, to appoint or remove the RTI commissioners, the information commissioners. See, a constitutional body is a very supreme body, no doubt in that. No one can play with the roles, responsibilities, functionings, and the protocols of the constitutional bodies, right? But on the contrary, see, I'm not trying to criticize, I'm just trying to be factual. On the contrary, the non-constitutional bodies, they are easily misused. Yes, easily misused. For example, in India, we have seen that how CBI, Central Bureau of Investigation, is often referred to as caged parrot. Come on, give me a break. Are you kidding? You are calling CBI a caged parrot, that it is being misused by the ruling governments, by the ruling central governments. Unfortunately, really unfortunately, yes. There have been instances, reports, news, multiple articles inside multiple newspapers, not just domestically, internationally, that they have criticized, and they have also provided the proper evidences as well as the examples when it was clearly visible that the central government is misusing the Central Bureau of Investigation. Senior level IPS officers, they do take charge of the CBI office, right? Senior, experienced, and very wonderful officers they are, those who are posted inside CBI. Then how come it is possible that the central governments, they have often misused this one wonderful particular organization known as CBI? Yes, it has happened. Why? First of all, CBI do not possess the constitutional authority. The removal, transfer, suspension, promotion of officers lies absolutely into the hands of the government, central government. And so they do attach the strings with their fingers to the neck of the CBI, and they just roll them according to their own needs. And whosoever the government is, incumbent, previous to previous, these governments have shown this scenario to the whole globe, not just India, to the whole globe, right? So, talking about now the another non-constitutional body in the very same lines, the Right to Information Act, when it was amended, and Section 13 and Section 16, which was talking about the appointment and removal of the Central Information Commissioner, CIC, and the State Information Commissioners. Earlier, there used to be a committee. Now, it is absolutely the government. And so, this humorous, sarcastic statement has came forward in front of us. That is, right to information has now become right to deny information. Okay. So, the context: over the years since its inception, the Right to Information Act 2005 has faced several challenges leading to its dilution and inefficiency in achieving its original purpose. What is the purpose of RTI? To provide information to the masses whenever called for, whenever asked for. So, in fact, you, me, whosoever is the citizen, could file an RTI, that is Right to Information, to the Information Commission with regard to any of the information you need. Obviously, there are some parameters that you cannot touch, like for example, the concerns of national security. You cannot ask that what is the nuclear launch codes of my nation, I want to know, being the citizen of India. No, you cannot, right? Because it is the question of national security. Obviously, you cannot ask such type of questions. But yes, in order to, when it comes to the other topics, like the budget, the investment by the government, how they have spent the money, the taxpayers' money, what is the expenditure, what is the income, and what is this project absolutely for, what is this project focused on, why is this project being created, what is the genesis of this project, etc., etc., etc. You can ask these questions, no doubt in that. And people, they every now and then, they do file the RTI as well. But the problem is, right now, these people, the citizens of India, they do lack the proper answers. They do not get the proper answers. So here we go. When we talk about the introduction, the RTI came in the year 2005, and it was introduced as a transformative law aimed at empowering citizens by granting them access to government-held information. Apart from that, this transparency law was seen as a step towards true democracy, enabling citizens to hold the government accountable. This is what was done. Okay, so this is what the genesis or the idea of RTI was. But what is going on right now? Okay, that is, people are filing the RTI, and in return what they are getting? An answer that we do not have the proper information over this, hence we cannot even transfer the information when I even don't have the information. So this is what the RTI comes with the answer. So RTI is a powerful tool to empower citizens, to curb corruption, to make India a corruption-free nation, to enhance transparency and accountability. Okay, as you can see, Article 19, Clause 1, Subclause A. It is referring to what? The fundamental right to speech and expression. I can speak anything, I can express anything. And also to gain the information is also my fundamental right to speech and expression, right? So RTI is also providing impetus to Article 19, Clause 1, Subclause A. And apart from that, yes, information commissions. The Act established the central as well as state information commissions, in short CICs and SICs, to act as an appellate bodies in the case of information denial. But what are they doing these days? Are they providing the proper answers? Unfortunately, no. The proper answers are not being given to the citizens. Why so? Please do let me know into the comment box. What will be your opinion over this? Okay. So moving on to the next topic for the day. That is here, systematic regulation of personal relationships. Well, why this topic is here? Personal relationship. Okay. I do have a girlfriend, I do have a boyfriend, I do have this and that. Why should I share this information with you? So, would be you having. Why should you share this information with me? When there is already a word mentioned that is personal, that is private. So why should I share this information? If I want to share, obviously I will. But if I deny that it is my private information, my personal information, and I'm not going to share it, then what's the problem here? And why it is this issue? So the issue comes with the context of the implementation of Uniform Civil Code that has been implemented very recently in Uttarakhand. The Uniform Civil Code, which was created with just one single aim and target, that is to enhance or actually create the system of equality when it comes to the civil laws inside the country. But since its inception, specifically in Uttarakhand, it is now a subject of discussion and debate for the whole world. Not just India, for the whole world. As you can see, Uttarakhand became the first Indian state to implement the Uniform Civil Code, placing private relationships under state surveillance. The liberals, they call it as the threat to their human rights, fundamental rights, to their privacy. And the people on the other side, those who are liberals, could be or could not be as well. They call it as a measure to curb the ongoing crimes that are happening with the live-in couples. Okay, as we have seen, there are n number of cases that there are live-in couples, those who are living together, those who are not married, and the one has killed another, chopped off the bodies in multiple parts, kept it in a refrigerator or a cement-filled drum, or has just drowned the body inside a river or a lake, or burnt it, whatsoever. N number of cases they have been there. But what will UCC do with that? And what if I provide my private information even to the government? Will it provide any kind of guarantee to me that yes, now I will not be chopped off by my partner? Now I will not be killed and kept inside a cement-filled drum by my partner? Will it provide any sort of guarantee to that? Well, once again, as I stated a couple of minutes back, it's a matter of discussion and debate. No one can guarantee the crime. Okay? So, what is the whole news? A survey of 2014 of over 70,000 respondents found that fewer than 10% of urban Indians had a family member who married outside their caste. And the fact, interfaith unions or relations were even rarer. Barely 5% of urban respondents reported any marriages in their family outside their religion. So, why it is wrong? See, guys, I need to just provide the, what we call it as disclaimer. I'm a very liberal person. I'm not trying to be orthodox. I'm not trying to be stereotype. Okay? I have a particular opinion and I follow my opinion. I do not want anyone to follow my opinion. If you like it, you follow. If you don't like it, you don't follow. On the very same side, I say these things to others as well. I like your opinion, I will follow it. If I don't like it, I will not follow it. But I won't even criticize. That is the actual liberal person. Right? वो slang चलता था ना हमारा social media पे. Once upon a time, we used to have this slang on social medias. My life, my rules. Yeah, that's true. Live your life, enjoy your life at your best, but please keep this thing in your mind. That your life, your life's enjoyment should not be the trouble to others' lives. It is very wonderfully stated inside the realm of the political science. That is, my rights are your duties and your rights are my duties. So we, according to the principles, according to the theories given by Jean-Jacques Rousseau, we talk about the concept of social contract. Yeah, the principles of natural justice when we talk about. So we live in a society and we are bound with a contract which we have signed by being the virtue of humans. That I will respect your thoughts and so do you. The vice versa relationship should be there. The two-way communication should be there between the masses. Right? So, if in that case, according to that, I am in love with a person outside my caste or community, is that wrong? Come on, guys, anyone with the answer? Is that wrong? What do you think? Is it wrong or not? I don't think so. Until and unless it is creating a ruckus in the society, it is not wrong. If I'm in love with a person outside my religion, is that wrong? No, it is not wrong. If I'm in love with a person outside my nation, then also if it is wrong, it is not wrong. Until and unless it is creating a ruckus in the society. If it is not troubling any individual, if it is not troubling any group of individual, that is the community, it's not wrong. Right? So this is what the whole survey tells us, the report tells us. That the crimes that have took place, it has took place majority of the times when the living couples, the living partners, they were from different communities or possibly different religions. Okay? If it breaks law, see dear, it's a very debatable thing, dear Bhavit. It's a very debatable thing to answer. What type of law? Okay, if it breaks law, but what type of law? Which law? See, I am living in with a person. Could be of same gender, could not be of same gender. Could be of same community, could not be of the same community. Could be of same religion, could not be of same religion. Could be of same nationality, could not be of same nationality. So how is it breaking any type of law? If it exists. And in my knowledge, so far, as of now, in India, no such law exists. Right? So, yes, if tomorrow a law is made, then if I'm doing it, then it is wrong. But till today, there is no such law. But but with the previous experiences we have, that what we have seen, the very famous case of, I guess it was the case of Pune, possibly Pune or Nagpur, the murder of Shraddha, right? The girl who was chopped off in multiple parts and her live-in partner kept her body parts inside a deep freezer. The very recent case of Meerut, where a wife has murdered her husband along with the help of her boyfriend. chopped off the body parts and kept inside a drum filled with cement, right? So all of these things are, yes, it tells us that the time has come for us to have a surveillance over these things. But at what cost? At the cost of the privacy of the individuals. If it does troubles the privacy of the individuals, then it's not the correct thing, right? So this is what the whole news is with regard to the Uniform Civil Code. So hurdles faced by the interfaith and live-in couples. Okay, legal and bureaucratic barriers. See, the Special Marriage Act of 1954 already had a 30-day mandatory notice period, making interfaith marriages a public affair. That is, to recognize them legally, it takes 30 big days. And in those 30 days, anything could happen with those couple. Then, the UCC in Uttarakhand now mandates live-in relationships to be registered, requiring multiple documents, religious approvals, and parental notifications as well. See, I'm not trying to be orthodox. See, I'm literally not trying to be orthodox, but the recent experiences we are having, I believe this is something that is disturbing the privacy. Yes, it is. But what else is the option available with us in order to save the society? Yes, Bhavit, but the community is not allowed to marry with other castes. Constitution allows community not. See, as I stated there, it's a matter of discussion and debate. Okay. Until and unless society leaves its orthodox and stereotype mentality, all of these things will exist. Why people are being killed? The people, they do live together, they do decide to live together because they are madly in love with each other. But what's wrong in that love relationship? Why it is converted into the hate story? That love story is easily converted these days into the hate story. And this hate story leads to the deadly, lethal, brutal crimes, right? So this is what the whole story is. So dear Bhavit, to answer your question, I will just say it is a matter of discussion and debate. As in the yesterday's session, we were discussing about that something that is legally correct could not be admissible by the society, and the vice versa. Something that is socially correct or admitted by the society could not be legally correct as well. And so does these interfaith live-in relationships and marriages they are. Okay, forget interfaith. In fact, live-in relationships with the same community, people with the same religion person is also something not admissible. And as I was stating, Uttarakhand's UCC has asked the live-in couples to provide such things. Is it not influencing? It is not infringing their right to privacy and right to life and liberty? It is. Yes. But so far, it has stand as a valid measure, as a valid and a strong tool in order to curb the crimes that are going on throughout our nation. Okay, I'm not just trying to be orthodox, as I stated. Okay, then the last thing, the failure to register a live-in relationship can lead to a 6 months of incarceration, that is imprisonment, and a rupees 25,000 fine as well. Okay, so what's your opinion, guys? I would like to hear into the comment section or after the class into the comment box. Okay, that do you agree with this thing? If so, then why? If not so, then why? Okay, just provide me the answers. Not now, after the class. Okay, right now we are moving forward. Okay, with the next ever topic. UIDAI notifies new rules for Aadhaar identification. Unique Identity Authority Identification Authority of India. Okay, UIDAI. Okay, it has came forward with the new rules for Aadhaar authentication. And what is the context here? The MeitY, that is the Ministry of Electronics and Information Technology, has notified amendments to the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act of 2016. Simply the Aadhaar Act of 2016. So what and who has done? It is done by MeitY. It has notified amendments to what? To the Aadhaar Act of 2016. What is the whole news about the key amendment that we talk about? So, the first thing, expanded the scope of Aadhaar authentication. That is, the amendment broadens the use of Aadhaar authentication to include both government as well as non-government entities for good governance, social welfare, programs, innovations, and knowledge dissemination and ease of living. Okay, so Aadhaar authentication, in short, is not just with the government. It is also now given to non-government entities for the sake of good governance, for the sake of better justice delivery. Simply speaking, social welfare programs. These changes will improve service delivery in various sectors such as e-commerce, travel, tourism, hospitality, or the healthcare. And this will also allow private entities to utilize Aadhaar authentication for secure, seamless, and trusted transactions. Right? So even now, the private entities could have the Aadhaar authentication. This is what the MeitY, Ministry of Electronics and Information Technology, has came forward with the Aadhaar Act, amendment to the Aadhaar Act of 2016. Okay. See the next big thing here. I think it is visible. It is visible, guys. The green paragraph thing. I think it should be visible. If it is not, please do let me know. Okay, yeah. So, new approval process for Aadhaar authentication process, how it is done. Okay, the new approval process. Application submission, any entity, government or even private or non-government, seeking Aadhaar authentication must submit an application detailing the intended use or the case to the concerned ministry or department, either central or state government. So if I am a private entity, okay, or maybe even the government entity, and I want to use Aadhaar authentication process, then firstly, I'll have to submit an application, okay, to the concerned department of the central or the state. And in that application, I must justify the use, the need, that is the legitimacy of the Aadhaar authentication. And further, review and recommendation. The Unique Identification Authority of India examines the request and approvals will be issued by MeitY. See the difference. The recommendation or the review will be done by the UIDAI. The UIDAI will only review your application. But whether it should be accessed, whether it should be granted or not, it will be the sole responsibility or the sole authority of the MeitY. So approvals will be issued by MeitY. Okay, that is the Ministry of Electronics and Information Technology. And the final notification, the concerned ministry or department will notify the entity after receiving the confirmation from the MeitY. So let's say, for example, we can understand it like this, that there is a body, okay, named as X. So it could be government or could be non-government. Okay. Now, this authority, this particular body, wants to have the Aadhaar authentication. Now, this body will have to write the application to the concerned department. Let's say, for example, it will be the Department of Road and Transport, for example. Okay. Now, this application, okay, this application will be reviewed. Reviewed by whom? It will be reviewed by the Aadhaar, UIDAI actually. The UIDAI will provide the recommendation. To whom? To the Ministry of Electronics and Information Technology. And the Ministry of Electronics and Information Technology, that is MeitY, will provide the final process to the concerned department. So in case, for example, we have kept the Ministry or the Department of Road and Transport. That's it. Okay, so this is what the challenges that have come in the Aadhaar Act of 2016. Okay, so moving on to the next topic for the day. Supreme Court's ruling on forest conservation. Okay, what is the news here? The context. The Supreme Court of India has directed the union government and the states to ensure that no reduction of forest land actually takes place without providing compensatory land for afforestation. The ruling is a part of an ongoing case challenging the 2023 amendment to the Forest Conservation Act of 1980. See, what is the news? The Honorable Supreme Court of India has issued the directions to whom? To the central government. And what are the directions? That while you are providing any land to any government or non-government entity for its particular use, so obviously there would be deforestation. So let's say, for example, if you are giving 1 hectare of land to any particular body for any particular use, that and the land belongs to the forest, okay, then before granting that 1 hectare of the land, for example, you will have to also create 1 hectare of land in the name of 1 hectare of forest land in the name of afforestation. Okay, so that we call it in Hindi, right? Ek haath de, ek haath le. Okay, so this is what the whole story is. So Supreme Court has directed whom? The government as well as the states to ensure that no reduction of forest land takes place without providing compensatory land for afforestation. Okay. Now, the Supreme Court's key directives. Very, very important. Guys, please be very specific because such type of questions, they do hold a very strong place in your prelims, because your prelims, your UPSC CSE prelims is also common examination for the candidate, those who are appearing not for the civil services examination, but the forest services examination. Though the mains of these two departments are different, but the prelims is common. So could be possible that inside your prelims examination hall, when you are solving your question paper, the other candidate that is sitting besides you could not be giving the exam for civil services. The very other candidates could be there sitting for the forest services. So that is why the questions with regard to zoology, botany, biology, agriculture, forest, wildlife, animal kingdom, etc., that is flora and fauna, they do dominate the question paper now. Okay, the reason is the prelims is common for civil services examination as well as forest services examination. Okay, so what is the Supreme Court's key directives? No reduction in the forest land. Okay, simply the court prohibited the use of forest land for development projects unless compensatory land is provided. And the next thing, linear projects require compensatory afforestation. If forest land is used for linear projects, such as, what are these linear projects? What is the definition of linear projects? Such as the development of roads, railways, and transmission lines. An equal amount of land must be afforested anywhere else. Okay, so linear projects, now you know umbrella term for linear projects. What are these linear projects? Anything related to the railway lines, electricity grid, or the road development. Could be highway, could be anything. Okay, so that is what an umbrella term known as linear projects. Next, dictionary meaning of forest to continue. Dictionary meaning of forest, that is, the court reiterated that the definition of forest should remain broad and all encompassing as established in the T.N. Godavarman Thirumupalad case 1996. Okay, so there was a case that is known as T.N. Godavarman Thirumullad case 1996, in which the dictionary definition of forest was given. Okay, and what is that dictionary definition of forest? Okay, we'll see that in the next slide. So, the Forest Conservation Act of 1980 was enacted to prevent deforestation and maintain ecological balance. What did the 2023 amendment changed in this Forest Act of 1980, or the Forest Conservation Act of 1980? The change was that. What was the change? It introduced section 1A, which narrowed the definition of forest to as declared forest, that is the forests that are only declared, okay, that are identified as forests, not those forests which are not identified as forests. And second, land recorded as forests in the government records after 1980, that is after the Forest Conservation Act of 1980, not before that. So there are many lands in many forest lands actually in the states, northeastern states, Chhattisgarh, Jharkhand, Madhya Pradesh, Rajasthan, okay, that are not even given the forest status through the Forest Conservation Act of 1980. Okay, so the misuse could be there because of the Amendment Act of 2023 into the Forest Conservation Act of 1980. And to avoid or eliminate that misuse, the Supreme Court has came forward with the directions. And see the next big thing here, concerns raised by petitioner. Petitioners argued that Section 1A weakened the forest protection by excluding nearly 1.97 lakh square kilometer of undeclared forest lands. Many of these forest lands, they belong to Northeast, to Gujarat, Rajasthan, Madhya Pradesh, Jharkhand, Chhattisgarh, the areas rich in forest. And there are even locations in the western and the eastern Ghats as well. Okay, so talking about the definition, the Supreme Court's stand on the definition of forest. Okay, actual definition of forest, that is the dictionary definition of forest. So court reaffirmed that the term forest will continue to have a broader meaning as we had in the T.N. Godavarman case of 1996. This means the forest lands will not be limited to the government recognized forests, but also not just the government recognized forests, but also forest-like areas, unclassed forests, community forest lands. That means any area that is having trees and plants and the greeneries, flora, fauna, whatsoever, okay, will be considered as the forest. It is not like that the government has classified it as forest or this area has been declared forest through the Forest Conservation Act of 1980. No, absolutely not like that. Any such thing. Simply speaking, any area with rich flora and fauna is forest. Okay. Now, the court ordered that this broad definition remain valid until all the states and UTs complete a consolidated record of the forest lands. And Supreme Court knows it also very well. For the governments to identify and consolidate the data and records of the forest lands in the area, it will take decades and decades for the governments to do. Okay, it's a very hectic task, retarding task, and no government would bother to do this. We'll be seeing later on. Okay, so this is why the Supreme Court has played a very smart game, clever and cunning game here, right? So the next topic for the day, the Supreme Court questions Assam on delay in deporting declared foreigners. Not just Assam. Not just Assam. Tripura, Nagaland, Arunachal Pradesh, Manipur, Mizoram, the whole of Northeast. In fact, West Bengal, Odisha, Bihar, UP, in fact, Maharashtra. We have seen that many people, they have been identified as Bangladeshi, as Rohingya migrants, immigrants, illegal migrants basically. How come this be possible? Why is this even happening? Why are we not deporting them? The Rohingyas, they have occupied a good chunk of land. Not only in Assam, not only in West Bengal. If you are active in social media, then you might have seen the videos in fact, onto the news channels as well, that there are many areas in Delhi, the capital of country, New Delhi, where there is a whole particular group of Rohingyas. They have grabbed the lands, okay, and they have created their shelters and they are living. They are illegal migrants. They do not even have a valid passport or a visa. They do not belong to this country. Okay. It's a big threat to the national security. And it's a big burden on the exchequer as well, on the resources of this nation as well. And now, the another concern. There are many foreigners in India, those who are not illegal migrants, also not the illegal migrants, but they are living in India. Their visa has been expired and so, but they are still in India. And many of these foreigners were identified in the state of Assam. And now it was the responsibility of the government to deport those foreigners to their respective countries. But still, even after their identification, there has been the news or the instance that the Assam government hasn't taken any cognizant action against those deported, declared foreigners. They're not being deported. Why so? So what is the context? While hearing a petition on illegal immigrants, Supreme Court has questioned Assam on indefinite detention of declared foreigners instead of deporting them. And what is the further thing? Directives issued by the Supreme Court. What are the directives? The Supreme Court emphasized that once a person is declared a foreigner, they must be deported immediately and cannot be detained indefinitely. It cited Article 21 of the Constitution, that is right to life and personal liberty, reinforcing that indefinite detention is unconstitutional. First thing. And second thing, the union government has been directed to provide further three things. Total number of declared foreigners in Assam, first. Details of how many have been deported so far, second. And third, the procedure being followed for individuals whose nationality is unknown. But still, I don't know for what good reasons on earth, still no action, no such proper, strong, cognizant action is visible from the government side. When the illegal migrants are the biggest threat to me, to my social fabric, to my growth and development, to my internal national security, to my sovereignty, then still, after knowing all of these cancerous issues, why the hell I am still silent? How can I be just a mute spectator? I am government. It is my responsibility, my moral obligation to safeguard my nation, my people, my citizens, my masses, and I must assure that nothing hampers the growth and development of my nation. And after knowing the issue, see, if I am unaware with an issue, then okay, that's not a big deal. That's not a problem. But after the notification, after the issue has been highlighted to me, after the issue has come to my notice, still I am silent, that means it's question on my legitimacy, my capabilities as a government. Whether I am potent enough to deliver what I possess as a power I possess, whether I am able to utilize it for the good, collective good of my nation or not. So that is why Supreme Court has given these directions. Okay. Now, about Foreigners Tribunal. There is also a Foreigners Tribunal. Okay, so guys, please be very specific. It's a very big topic with regard to the current affairs. Okay, with regard to the prelims questions actually. The Foreigners Tribunal, right? Established by the Foreigners Tribunal's Order of 1964 under Section 3 of the Foreigners Act of 1946. See, you need not remember all of these things, but yes, one thing, established through the Foreigners Act of 1946. The Foreigners Tribunal has been established with the Foreigners Tribunal Act of 1946 or the Foreigners Act of 1946. The purpose simply to enable local authorities to refer suspected foreigners to the tribunals. And exclusivity to Assam. Currently, the Foreigners Tribunal operate only in Assam, while other states handle illegal immigrant cases under the Foreigners Act. Now you can understand how big issue it is in Assam. Okay, the Foreigners Act is active throughout the states, but the Foreigners Tribunal is only active in Assam, and it's a big question as well that could be asked in the prelims. The other states, they do deal with the illegal migrants through the Foreigners Act of 1946, whereas the Foreigners Tribunal, though established through the Foreigners Act of 1946 only, is active only and only in the state of Assam, because Assam is a state which is most heavily burdened and troubled with the illegal migrants, specifically from Bangladesh and Myanmar. We don't know how many of them are terrorists. Could be from ISI, could be from ISIS, could be the agents of China. We have seen there have been numerous cases. We don't know how many of them from Lashkar, Al-Qaeda, Taliban, or whatsoever. And yes, these are the people who are very, very radical. Those who are disturbing the local law and order and the peace and the harmony situations. Manipur is burning, and this flakes of burning in the Manipur could reach Assam very soon. I'm not saying that Manipur is burning because of illegal migrants. No, Manipur's violence, Manipur's civil war actually is all done by the Indians only, by us only. As of now, the present reports what they do tell. Right? But what if it reaches Assam? The flakes, if they do reach Assam, and the Rohingyas and the other illegal migrants from Bangladesh or Myanmar, or could be from Pakistan or some other nations as well. What if they do utilize it for their hostile intentions? What will happen? It will disturb the whole of the region, right? Okay, so that is why it's now time for us to act, and that is why Assam is being highlighted with such issues, and that is why the Foreigners Tribunal is active there. Okay. So, composition, if you can see, each foreigner tribunal is led by a member from the judiciary, advocacy, or civil service with judicial experience. So, how many people are there? What is the logic? So, there are people from judiciary, from advocates, and from civil services as well. Okay, the exact numbers are not given, but at least 3 different departments. The persons should come from 3 different departments. And next thing, the case disposal, the very wonderful thing. The Foreigners Tribunal must conclude cases within 60 days. And failure to prove citizenship can result in detention and eventually deportation as well. So Foreigners Tribunal, they have been given a specific time. And what is this specific time? That is, they must dispose of the cases once it has come to the notice within 66 days. That is, through the Foreigners Act of 1946, established the Foreigners Tribunal, and the Foreigners Tribunal time period, 60 days. Okay. So guys, I hope everything is being clear. Koi bhi doubt nahi hoga. There would be existing no doubt in your minds. Right? Okay. So moving on to the next topic. Governor assent to the bill. What is the context? The Supreme Court asked what Tamil Nadu Governor R.N. Ravi found so gross about the 12 bills the state government sent him for assent that they were kept pending for over 3 years. Before entering into the topic, let's just understand the basics. How a bill is converted into an act. Okay. At the central level, that is the union level, or at the state level. At the central level, the bill could become act only after the assent of the Honorable President of India, right? And at the state level, it is Governor of the states. Now, the governors of the states as well as the President of India, they do possess some veto powers. What are these veto powers? So, with regard to the President of India, President has got the suspensive veto, the pocket veto, okay, and absolute veto. But this absolute veto only in case of state bills. And not the bills passed by the Union Parliament. Okay. And when it comes to the governor, what do the governors they do have? Governors have got one more extra veto that is known as transferable veto. The governors of the state could not give the assent. In fact, they could ask the president to give the assent to a certain type of a bill passed by the state legislature. Okay. So what is the whole news? Okay. It is with regard to the veto only. Actually, the pocket veto. What is this pocket veto? By using the pocket veto, the president or the governors, they just withhold the bill with themselves. They do not provide any kind of rejection or acceptance to the bill. The bill is sent to them for the approval, for the assent, and what they do in return, if they find something not so good with that bill, okay, they might just keep the bill with themselves, neither accepting, neither denying. And that is known as the pocket veto concept. Right. Now, see the news. Tamil Nadu's governor, Mr. Ravi, has kept around 12 bills with himself since last 12 years. And now the question is asked by the Supreme Court that, Mr. Governor, please tell us what makes you to withhold the bills using your pocket veto for 3 long years. We need an answer. So what is the constitutional position for it? Article 200, the power of governor related to the bills. What governor can do with regard to the bills passed by state legislature? Governor could grant assent to the bill. Okay. Could withhold the assent to the bill. That is withhold, not even rejecting. And the third thing, reserve the bill for the assent of the president or consideration by the president. Right? Return the bill. This is what is known as suspensive veto. Until and unless it is the money bill, okay, it is done by the president as well as the state governors. That is what is simply known as suspensive veto. If the recommendations for the amendment is accepted by the parliament or by the state legislature in case of governor, okay, then also good. If not, the bill is sent back as it is. Then in the second instance, the president or the governors, they are bound to give the assent. Okay, so this is what is known as suspensive veto. Okay, so the governors, they have got these 4 types of veto with themselves. Okay, now, which veto is being used by R.N. Ravi this time? That is the governor, honorable governor of the state of Tamil Nadu, pocket veto. See, if the bill is passed again, the governor cannot withhold the assent in the case of suspensive veto. And for this, we have got a case here as well. That is Nabam Rabia and Bamang Felix case 2016. A very famous case. Please make it clear. The name Nabam Rabia and Bamang Felix case. When it happened, 2016, very recent. So in this, the Supreme Court limited the governor's discretionary power under Article 200 to merely deciding whether a bill should be reserved for the president's consideration, asserting that such actions are open to judicial review. That is simply speaking, the Supreme Court in the Nabam Rabia and the Bamang Felix case of 2016 stated that if the governor has sent a bill for the consideration of the president, then in that particular action, is judicial review possible? Yes, judicial review is possible. And which is the reference? What is the reference of the case? Reference of the case is once again Nabam Rabia and Bamang Felix case 2016. Now, the constitutional provisions. Article 201, presidential assent for the reserved bills by this governor. Okay, president can grant the assent, can withhold the assent, can return the bill for the consideration, and can also reject the bill. So president has got absolute veto. Okay, absolute veto just in case of state legislative assembly bills and not the union parliament. Okay, now when we see the reconsideration of reserved bills, the legislature must reconsider a returned bill within 6 months by the president under Article 201. And once passed again, it is presented to the president, not the governor, because it is the recommendation of the president. It has been now transferred to the president only, right? And the president is not obligated to grant assent to the reconsidered bill. Even if the president has recommended the amendments to the bill, then also president is not bound to grant assent his or her will. Okay, right? So this is what the constitutional provision is. And now the categories of state bills, they should be reserved by the governor for the consent of the or the consideration of the president. So it is the discretion of the governor to reserve the bills for the consideration of the president, as well as it is also mandatory for the governor in some certain types of the bills to take the consent or the assent of the president. So it happens two ways. Okay, understand both the ways very clearly. First thing is the discretion of the governor. Governor under Article 200 can transfer the bill to the president, can transfer any bill to the president for assent. So this is the discretionary power of the governor. But now the next is the cases where it becomes mandatory for the governor to transfer the bill. Okay, to transfer some certain types of bill for the assent of the president. What are these certain types of bills? Mandatory reservation. Bills that diminish the powers of the High Court. First thing. Secondly, bills imposing taxes on water or electricity under certain conditions. Next thing, bills related to the financial emergency provisions. And next, discretionary reservation. So the governor can go ahead for with the discretionary power for any other type of bills. But if a bill is related to the interstate trade and commerce, the taxation policy, or in fact, when it is related to the powers and authorities of the state high courts, then in those conditions, the governor is obligated, it's in the obligation of the governor to send the concerned bill for the assent of the president. The governor do not possess the authority to grant assent to such type of bills. Okay. So next news, Meghalaya's demand for special provisions or the special category status. What is the context? A regional party in Meghalaya has proposed bringing the state under the purview of Article 371 to help resume rat hole coal mining. Okay. So, rat hole coal mining has been banned since April 2014 by the National Green Tribunal due to the environmental and safety concerns. Right? Simply, two things that are in news that are to be discussed with this news. Firstly, yes, what is Article 371? And secondly, what is rat hole mining? Okay, so let's discuss them. Here we go. Current situation of Meghalaya. Meghalaya has got ADCs, that is Autonomous District Councils, under the 6th schedule, that is Article 244 Clause 2 and 275 Clause 1, which gives limited autonomy to tribal regions. Autonomy, but limited. Autonomous District Councils, they do possess, they do work like a small parliament or a small legislative council itself, right? Due to this, the NGT ban on rat hole mining remains enforceable dispute. ADCs having control over the land and the resources. So the ADCs, they do have control over the land and the resources. But since the rat hole mining has been banned, still there are instances faced by the people of the Meghalaya where the rat hole mining is still witnessed. Okay, and this particular rat hole mining is authorized by none other than their ADCs itself. Majority of the times we have seen that. Okay, so for that sake, one of the Meghalaya's political party has actually made up a demand that please insert Meghalaya into the section 371. It is Article 371. Okay, so now, what do we understand with Article 371? It provides a special provision for certain states in India to address regional concerns, cultural preservation, and economic development. Okay, these provisions vary from state to state. Article 369 appears in Part 21 of the Indian Constitution, titled Temporary, Transitional, and Special Provisions, and through which Article 371 extends its powers. So it extends to 11 states. 6 of them are from the northeastern areas, whereas the provisions aim to preserve the tribal culture. Okay, so simply speaking, Article 371 and Article 369, both of them, what are they? So Article 371, it provides some special provision for some certain states, like for example, Maharashtra and Gujarat, okay, to address some regional issues, some regional concerns, could be related to culture, preservation of the nature, or some economic development as well. And we know it very well, the biggest impetus to Indian economy comes from 2 different states, okay? That is Maharashtra and Gujarat. It's not like that other states do not. Other states also do. But the majority of the contribution comes from the states of Maharashtra and Gujarat. Okay, when it comes to the economic growth and development, these are the 2 states which holds rank 1 and 2 positions. Okay, interchangeably they do possess, right? So in the very same sense, Meghalaya's political party has demanded that yes, keep us as well in under article, special status under Article 371 to have some regional concerns as well as natural preservation, cultural as well as natural preservation. Why? Because something is going on in Meghalaya. What is that? It is the rat hole mining. What is the rat hole mining? It is not a big mining, simply rat hole, like a small hole, small mining. Okay, it is nothing new. Okay, simply understand, rat hole mining means a small mining area, and which is a big ecological disaster as well. So in Meghalaya, many instances were there where rat hole mining used to be carried forward, but after the year of 2014, this rat hole mining was immediately declared as invalid. But still, Meghalaya faces the issues with related to rat hole. Okay, so that is why the party has came forward with a demand that provide us protection under Article 371. And now talking about Article 369 as well. It's in Part 21, okay, and titled Temporary, Transitional, and Special Provisions. It has given to 11 states so far, and out of those 11, 6 of them are into the Northeast India, where the provisions aim to preserve the tribal culture. Okay, so yes, Meghalaya is part of Northeast and is part of Article 369 as well. So it has been provided some special provisions to protect the tribal culture, as we know, the most wonderful landscapes and the most rich culture, one of the most rich culture in the tribal history of India, comes from our wonderful state of Meghalaya, where we have seen the three wonderful hills, the Garo, Khasi, and Jaintia hills, with wonderful tribal culture of the Garo tribe, the Khasi tribe, and Jaintia tribes. Okay, these are the tribes with rich culture, rich history, and a very wonderful scenic view of Meghalaya. Okay, we need to preserve it, and we need the government as well as the judiciary both working hand in hand for the sake of protection of the natural environment. And this natural environment is not just natural environment, it is also the life and the livelihood of the local tribal population. Okay, and we cannot hamper their rights at any cost, right? So for that sake, the demand has came from the state of Meghalaya to insert Meghalaya under Article 371. Okay, so moving to the next topic. What is the next topic here? Supreme Court's stand on death penalty 2024. What is the context? The Supreme Court did not confirm a single death sentence for the second consecutive year in 2024. Capital punishment, basically. Do we really need capital punishment? A debatable topic once again. The liberal side of the society could not be in favor of death penalty, but the other section could be in favor. If you ask me that do I favor death penalty, I do. When it comes to the heinous crimes, when it comes to the brutal, barbaric actions performed by any individual, regardless of his or her gender, color, caste, creed, religion, community, etc., etc., the death penalty is needed as it sets an example. But the news here today is that since last 2 years, no single death sentence has been given. And what is the whole scenario? Let's understand it. The death penalty and the rarest of rare doctrine. The Supreme Court, there is a case reference. The case reference is Bachchan Singh versus State of Punjab 1980. Established the principle that death penalty should only be imposed in the rarest of rare cases. And make no mistake, guys, this rarest of rare case is nowhere, literally nowhere defined in the constitution, in the rule books or anywhere. Okay, what is this rarest of rare? What will be the parameters to identify any crime as rarest of rare? It is not yet nowhere justified. No such measures, no such elements are provided yet. Okay, just the doctrine has been provided through the case of Bachchan Singh versus State of Punjab 1980. Okay. Further, the court emphasized that the death sentences should be imposed after considering both aggravating and mitigating circumstances surrounding the crime. Aggravating circumstances, factors that may lead to the death penalty, that is pre-planned murder, exceptional depravity, okay, and murder of the public servants. These are the things that are so far justified that death penalty will be given in these three conditions. If the murder is pre-planned, second one, if it is very grave, okay, involves extraordinary cruelty, okay, very barbaric, and the last one, if the murder is of a public servant, then in such cases it will be considered as rarest of rare. But are these three conditions only rarest of rare? No. The court, while delivering the judgment, could also provide any other incidents, any other action as rarest of rare. For example, my deepest sympathies as well as anger to firstly the victim of the family and anger to the culprits. I will take the word culprits, keep it plural noun, because it was not a single person. The Arjikar Medical Hospital case, Calcutta 2024. The victim was brutally assaulted, raped, and killed with all barbaric actions possible. The post-mortem report clearly stated that it is not an act done by just one single individual, but just one single arrest, I think named Sanjay Roy. Just one person was declared guilty. I'm not saying Sanjay was not guilty. He was also guilty. According to the post-mortem report, at least it stated that 5 to 7 people, or could be more, were involved in the rape and murder, the barbaric action performed against one individual doctor. There were people, more than 5 to 7 people involved. But still, just one conviction. And unfortunately, the Calcutta court didn't provide a death sentence to Sanjay Roy. Wasn't it not much rarest of rare? It was as brutal as the 2012 Nirbhaya case. Justice was served to Nirbhaya while all of those were hanged. Just keeping the exception of that so-called juvenile. So-called juvenile. The culprits are still yet unknown. Forget about justice. The culprits' name are even not known. How the case was handled by the local authorities, the whole globe is aware that how that particular room where the crime happened was destroyed overnight. And just one name came forward. And that one name was also not given death penalty. Isn't it not the rarest of rare? What else do you want to accept in the rare of rare? What else do you want to happen? Then only this will be added into the rarest of rare. Rape is itself rarest of rare. And this was the most barbaric thing. I read the post-mortem report and I couldn't read it. I was not comfortable reading it much. After reading a couple of lines, I just closed that particular file. So, why was not Sanjay Roy given death penalty? Wasn't he the actual one who deserved death penalty? And that is why the word I took, culprits, plural noun, right? Sanjay Roy was not the only culprit. He was one of those culprits. And even he didn't got the death penalty. Though the CBI has made it very clear that they have appealed to the State High Court, Calcutta High Court. But still the Calcutta High Court is yet to give the judgment whether Sanjay Roy be given the death penalty or not. If it is not even the rarest of rare, then what will be the next rarest of rare, right? So this is what the things are going on. We will be discussing this in some other topics as well. Okay. So now moving on to the next topic for the day, that is Supreme Court directs ECI, that is Election Commission of India, to ensure EVM data is not deleted during verification. Okay. Many incidences, many news we do experience and witness with regard to the concerns over EVM being hacked. Those who win, they deny. Those who lose, they raise the concern that EVM was hacked. Right? And now the directions has come from the Supreme Court that until and unless the data is being verified, please, dear Election Commission, make sure that the data is not deleted before verification. So what is the context? The Supreme Court asked the ECI to ensure that the polling data is not deleted from the EVMs, that is electronic voting machine, while they are being verified. And if those such things happens, then the ECI should be made answerable. So about Supreme Court's direction, what is the direction here? No erasing or reloading of data should happen. And clarification and verification process should be there. What is that? The burnt memory microcontroller, that is, should be checked in the presence of the requesting candidates. So if a candidate has requested or has raised a concern that I believe that the EVM through which the polling was done in my constituency was hacked or was malfunctioning, then the burnt chip there is the burnt memory that is known as the microcontroller, okay, should be checked in the presence of the requesting or the litigating candidate. First thing. Second thing, engineers from the EVM manufacturers must certify that no tampering has occurred. And next, a reduction in the verification cost. The court observed that the current cost of rupees 40,000 per EVM verification is too high and directed the ECI to reduce the cost. So basically, cost is not much big of the concern here, but yes, the presence of the candidate while the microcontroller is being checked, or the burnt chip, simply calling the burnt memory, is being checked, and apart from that, the presence of the particular candidate, the litigant, should also be made sure. Okay, so this is what the directions they are given to the Election Commission of India for the sake of EVMs, right? And the first and foremost thing, please make sure before the verification is done, the data is not reloaded, neither it is deleted. Okay, now see the next thing, key aspects of the EVM verification process. Candidates eligible for verification. Which candidates are eligible for verification? Only those candidates, those who have secured the second and third place in the election can apply. Not the one who has secured the fourth, fifth, sixth and so on position. And now you have lost. Abhi nahi aane ka. Okay? Like that. Only the candidates, those who have secured the second position and the third position, they can only apply for the EVM verification. Next, scope of verification. 5% of EVMs per assembly segment can be checked. Not all of them. Can we check all of the EVMs? No. Let's say if in a constituency 100 EVMs were there, then out of them only 5, that is 5% could be checked. Application process. Candidates must submit a written request within 7 days of the result. It's not like that you will come after 2 months. Oh, I believe EVM was hacked. Hacked. Abhi go. Okay? Come within 7 days only. Then only your application will be accepted. It should be written first of all. Next, responsible authority. Who is the responsible authority? The DEO, that is the District Election Officer, in the coordination with the engineers, will oversee the verification. And last, cost and refund. Candidates must bear the cost of verification, that is rupees 40,000, which Supreme Court has stated it's too much, but they will be refunded if tampering is found. 40,000 return milega. They will get 40,000 rupees return if the tampering was found. Okay, nice. Keep going. Wait for the next election. Secure this 40,000 rupees. You will utilize this in the next elections, right? Good. So, what is the process? Who can apply? Who is eligible? The rank second holder and the rank third holder in the election. All the EVMs? No, 5% only. Apart from that, time period 7 days after the declaration of the result. Application should be oral or written. It should be obviously written. And lastly, who is the responsible, who is the actual personality to be appealed? It will be the district election officer. The nodal officer will be the district election officer along with the engineers of the EVM, right? And who will bear the cost? The cost will be borne by the litigant. That is rupees 40,000 rupees as of now. And is this cost, is this money refundable? Yes, it is refundable in case the tampering is done. If the tampering is not done, then forget that 40,000 rupees as well. No problem. Next news. The Supreme Court disposes PIL on mob lynching and cow vigilantism. What is this nation witnessing right now is something that we have been trying to avoid since ages. It's not like that this is a new thing. It is something which we are trying to avoid since ages. In 1958 or 59, positively 58, I think, if I'm not wrong, if either 1958 or 1959, Hanif Qureshi versus the state of Bihar happened. In that, Supreme Court clearly gave the direction that a cow who is milching should not be slaughtered. Cow or buffaloes, okay, the female buffaloes, those who are milching, they are a subject not to be slaughtered. This is what the statement, the directions, the orders issued by the Honorable Apex Court. Okay, that is the milching, the cow which is fit enough, not just milching, but is fit enough, should not be slaughtered. But a cow or a buffalo, okay, the female buffalo that is, which is now not so fit enough, okay, or in the last stages of the life, could be slaughtered. This is what the Supreme Court's guidelines are. The judgment of the Supreme Court is in the Hanif Qureshi versus the state of Bihar case, positively 1958 or 1959, maybe. Okay. Now, suddenly, I will call it suddenly only. I am also someone I favor vegetarianism. I favor that, okay, you must not eat animals. But it's my opinion, right? As some 30, 40, 50 minutes back, we were discussing that my opinion should always be my opinion and your opinion should always be your opinion. If I like your opinion, I'll follow it. If I don't, then it's okay. If you like my opinion, then you will follow it. And if you don't, then also it's fine. Not a big deal, right? So in my opinion, okay, cow is a holy creature. I say, okay, do not slaughter the cow. But I say, I will not slaughter the cow. If you are slaughtering, then I should follow the legal measures, the legal methods to save the cow. I should not become the moral police and should indulge in any kind of a violence. Okay, because now that will hamper the society as a whole. It will, for sure. So this should be my responsibility. And now the cow vigilantism is something that is more frequently seen in India. Very recently in Haryana, in UP, parts of UP, in parts of Haryana, parts of Bihar as well, and parts of Delhi as well we have seen, as well as Maharashtra. Okay, that because of this cow vigilantism, many of the incidences have happened which have resulted in much severe violence, right? So this much severe violence could be avoided if we follow the legal safeguards, the legal measures, rather than inciting violence. So what is the whole story? What is the context? The Supreme Court has disposed of a PIL, that is public interest litigation, that sought action against incidents of mob lynching and cow vigilantism. So what is the whole story? Here we go. Key observations by the Supreme Court. SC observed that the matter had already been addressed by in the 2018 case of Tehseen S. Poonawalla versus Union of India. A reference has been given, another reference. One reference already I stated, Hanif Qureshi versus State of Bihar, and another one, Tehseen S. Poonawalla versus Union of India. The court emphasized that the directions issued in these, in the Tehseen Poonawalla case are binding on all authorities under Article 141 of the Constitution. That is the power of Supreme Court to issue the directions that is applicable throughout the nation, throughout the territory of India. Okay. Next, Supreme Court stated that monitoring incidents of lynching and vigilantism across the states from Delhi would be impractical. Okay. So, have surveillance, but have it wherever it is having. Not just from Delhi, that is the center. That is from every location. You must be vigilant. Yes, you must be monitoring these issues, but not just from one location, from all the different locations. Okay, this is what the Supreme Court's guidelines in the Tehseen S. Poonawalla versus Union of India. What is the further directions and what is the case here? The preventive measures. All states were directed to appoint a senior police officer as a nodal officer in each and every district to prevent mob lynching incidences. It started in the year 2015 with the mob lynching of a person named as Ikhlaq in the territory, in the area of Dadri in UP, near Delhi NCR region only, okay, near Greater Noida region. There is a place known as Dadri. A person who was named as Ikhlaq was lynched, mob lynched, that is killed as well, on the pretext of consuming cow. though no such witnesses or no such concrete evidences were present to prove that a clerk was consuming cow. But a mob entered the house and lynched a clerk and killed as well, right? So this lynching actually was not justified until and unless the present concrete evidences and witnesses are available. And even lynching, even if the witness and evidence is available, then also lynching is not justified. Okay, for that case, for that particular thing, we have got the police, we have got the administration, we have got the judiciary. I must make the authorities aware of the case, aware of the incidents, and then leave it to the discretion, to the wisdom of the authorities, how, when and how they are dealing with such thing. Okay, so in a civilized society, even if the evidences and witnesses are available, lynching is basically nowhere justified, right? So as what we can see, states are required to identify areas where lynching and cow vigilantism were prevalent and increase police patrolling in those regions according to the Supreme Court's guidelines, the directions which came after the Tehseen S. Poonawalla case of 2018. The Supreme Court instructed social media platforms to curb hate speech and fake news that could incite mob lynching, as well as punitive measures. The fast-track courts to be set up in each district to handle lynching cases with priority. Well, we should call it as top priority. Okay. Now, the guilty should be punished with strict penalties, including life imprisonment for lynching-related crimes. This is what the Tehseen S. Poonawalla case of 2018 has given to us. That is the directions given by this Honorable Supreme Court after the case. Next, the Corruption Perception Index of 2024. The most interesting topic for all of us Indians. The Corruption Perception Index, right? Let's see what is the Corruption Perception Index. What is the context? The Transparency International. The name of the organization is Transparency International. It has issued the result, the report, that is the Corruption Perception Index of 2024, which highlights the state of public sector corruption worldwide, right? Not just India, worldwide. So what is the whole scenario about the Corruption Perception Index? First of all, that is in short CPI. See, do not misunderstood it with the Consumer Price Index. That CPI is different. Here we are dealing with the Corruption Perception Index. What is this? The global average score remains 43, which is unchanged from 2023. So what is the CPI score right now? 2023 and 2024, they do share same rank or the same score, that is 43. More than 2/3 of the countries scored below 50. India ranked 96th out of 180 with a severe score of 38, but a decline of 1 point from the previous year. Okay, last year we were 97 and this year we are 96. Performance to theek hai. Overall performance is nice. 1 point decline. Nice. Good. Keep it up. Okay, what is the score? 38. What is the rank? 96 out of 180. Okay. How CPI measures corruptions? What are the points or what are the elements while Transparency International, when they do create up this report, they do keep in mind while formulating the report? Okay. So what are the measures? The CPI ranks 180 countries and territories based on the perceived corruption in the public sector. The score is calculated on a scale of 0 to 100. Okay. 0, highly corrupt. 100, very clean. Apna score, apni ranking. What is our score, our ranking? Score is 38, ranking is 96. Too bad. It uses 13 data sources, including reports from World Bank, World Economic Forum, and private risk consulting firms. See, the two organizations are clearly defined. World Bank and World Economic Forum. Okay. The other 13 organizations, the 13 data sources are there. So 2 are defined, that is the World Bank and World Economic Forum. The other 11, they are not justified. Okay, they are simply stated as private risk consulting firms. Okay, now Transparency International. What is Transparency International? It is a global non-governmental organization. First of all, it's an NGO headquartered where? In Berlin, that is in Germany. Established when? It was established or founded in the year 1993. And it works for what? To combat corruption, promote transparency, and hold governments accountable. This is what their role is. And apart from that, the CPI, that is the Corruption Perception Index, it's a flagship report released annually since 1995. See, the Transparency International, it was established in 1993. But the first report came in the year 1995. That is, the first CPI report came in the year 1995. So it is the 2024. Okay, so far 30 reports have been there, and our ranking has been between 95 to 100 only every year. Okay. Next, decriminalization of politics. We need our politicians to be very honest. Before honest, we need our politicians not to be criminals. In the next couple of minutes, the data that you will be encountering would lead you to question the democratic state and the social fabric and the authority of your representatives. This is not any warning. This is just a disclaimer that I'm giving. In next couple of minutes, you will be compelled to think. Literally, you will be compelled. Think what's happening in my country. Are my representatives, my politicians, my leaders really worth it? But let me be very honest. Even if you think, nothing will change, because it's we only those who vote for the criminals. It's no outsiders, right? See the context. The Supreme Court is currently hearing petitions seeking a lifetime ban on convicted individuals from contesting elections. And it has sought a fresh response from the Election Commission of India and the Union government on this. There should be a lifetime ban once a person is declared a criminal. So legal provisions on disqualification. So we're not dealing with the anti-defection law. We're not dealing with the Schedule 10 of the Indian Constitution, right? Okay. Not Article 102, 191. No. We are just dealing with the provisions on disqualification. That is, firstly here, the representation of the People's Act of 1951. That is the RPA 1951. What it says. See the theories. Firstly, Section 8, Clause 3 of the RPA disqualifies a person convicted of a criminal offense and sentenced to at least 2 years of imprisonment from contesting elections. Okay. The disqualification lasts for 6 years after release. Section 8, Clause 1 disqualifies persons convicted under laws for heinous crimes like rape, untouchability, unlawful activities, and corruption. Okay, unlawful activities is justified under UAPA, that is Unlawful Activities Prevention Act, and corruption under the Prevention of Corruption Act. So these individuals remain disqualified for 6 years post-release, irrespective of their sentence duration. Indira Gandhi is an example, and many of them, they are examples, right? So this is the present legal provisions on disqualifications. Present, okay? And this is what has been challenged in the Honorable Supreme Court. See, Section 11 allows the Election Commission to remove or reduce the disqualification period of a convicted person. 6 years it is there. But through Section 11, on the discretion of Election Commission, the Election Commission could reduce that particular time period, that particular freezing or cooling period, that is disqualification from contesting the elections. Next, for example, in 2019, See the example here, very deadly. Prem Singh Tamang, okay, from Sikkim, had his disqualification period reduced from 6 years to 13 months. As I stated, you will be compelled to think what's happening. Okay, enabling him to contest a by-election despite being convicted under the Prevention of Corruption Act. Election Commission used Section 11. Okay, and the 6 years time ban was reduced to just 13 months, 1 year, 1 month, which made him contest the by-elections. Cholo. Supreme Court's past judgment on decriminalization of politics. There is a commission, there is an organization in India, as we were discussing in the first hour of our session today, about ADR, Association of Democratic Reforms, which provides report. We'll be discussing the report of the ADR as well. Nearly 55%, 50 to 55% legislators, not politicians I'm talking, legislators, those who are elected MPs and MLAs. Okay, politicians, they are different, and legislators, they are from the umbrella of politicians. Okay, legislators, that is those who are elected MPs, MLAs or MLCs, whatever. 50 to 55% of them, they do face severe criminal charges against them. Call it the charges of rape, murder, extortion, corruption, etc., etc. Right? See the Supreme Court's judgment so far. So ADR case of 2002, Supreme Court mandated disclosure of criminal records of all the candidates contesting elections. First thing. Second thing, the Lily Thomas case of 2013. Supreme Court struck down Section 8 Clause 4 of the RPA, that is 1951, which allowed sitting legislators to continue as members even after conviction if they filed an appeal. First thing. Now an MP or MLA is immediately disqualified upon conviction. Immediately. Okay. And a PIL, the PIF, Public Interest Foundation versus Union of India 2019. Okay. What it stated. Political parties to publish the criminal record of their candidates on their websites, social media, and local newspapers. This is what Supreme Court's discretion directions they have been. But do you think all of them, they are being followed? Barely some of them. Okay. See the report, election data on criminal records. According to 2024 ADR report, 251 MPs, that is 46% out of 543 members in Lok Sabha, have criminal cases against them. This is 2024, the present incumbent MPs. 171 MPs, that is 31%, face serious criminal charges like rape, murder, attempt to murder, kidnapping. They are inside parliament creating laws for the nation. LOL. Big LOL. Right? Winning probability. Candidates with criminal background had a 15.4% chance of winning, while clean candidates had only a 4.4% chance of winning. Sarcasm and humor, when it enters the realm of politics, it's deadly. And this is the humor of the Indian society. If you are having a clean record, your chances of winning is 4.4%. But if you're having a criminal record, your chances enhances up to 15.4%. Right? Enjoy democracy. This is what the data is given by ADR, Association of Democratic Reforms. Right? So, as I stated before starting this topic, you will be compelled to think democracy, we need deadly reforms, immediate reforms, right? Okay, moving to the next topic, President's rule in Manipur. The Kuki and Metis community, they both are in conflict since last couple of years. Since then, the governments, state as well as the center, have failed to formalize any sort of solution. But the issue is not just domestic. There have been many news. In fact, I guess December last year itself, December or January this year could be, Starlink satellite equipments were found in Manipur. Starlink is a company owned by Elon Musk operating in America. How come that possible that the satellite equipments of Starlink of America is found with the militants in Manipur? This is not just a news. This is way beyond that. It is letting us know that there are parallel galaxies working inside Manipur that we can't see with our open eyes. Or in fact, if we can see with our open eyes, we cannot identify it as an actual problem. One of the states with very rich landscapes, good greenery, scenic views, and one of the richest tribal communities with regard to their culture and traditions residing inside our state of Manipur. The Manipuri dance, which is the classical dance of India, performed by the Meba and the Mabi, that is the priest and the priestess respectively, is said to be the oldest surviving art form in the human race. Oldest surviving art form of the whole human race, not just Manipur, Northeast, India or Asia, whole globe. It is said to be older than the recorded history. The Manipuri dance, its origin is a mystery. Even history doesn't know it, right? So my Manipur is very beautiful. It's my Manipur, no doubt in that. It's our Manipur. But it's burning. The people are inside a civil war, the clashes. So we have failed to found and formalize a proper solution yet. But I think the solution would come quite soon. And before that, the president's rule has been imposed inside the state of Manipur. And what is the context here? The president's rule is imposed in Manipur for the 11th time. President Draupadi Murmu has issued a proclamation under Article 356 of the Indian Constitution after receiving report from the governor Ajay Kumar Bhalla. Okay. So constitutional provisions regarding the president's rule. First of all, Article 355, as we were discussing in yesterday's polity class, the first polity class we have yesterday. Okay, so we discussed that India is federal with unitary bias, the union of states we are. So in India, the center plays the role of the big brother. So under Article 355, it is the duty of the center to protect the states from any kind of internal as well as external aggression. And so for that sake, Article 356 and Article 365, they have been facilitated to the center. If the constitutional machinery fails inside any state, then the Constitution provides this authority to the center to implement president's rule into that particular state under Article 356 and 365. So, approval. President's rule must be approved by both the houses of the parliament within 2 months. Okay, with a simple majority. 2 months of what? Let's say, for example, today it's 23rd of March. And today in any state, president's rule has been imposed. So from here, 60 days. Months, according to the Constitution, are calculated on the basis of 30-day period, not 31. Okay. So according to the Constitution, month is 30 days, not 31. So 60 days from the proclamation, the president's rule must be passed by both the houses of the parliament with simple majority. That is from 23rd March to 22nd April, 30 days. From 22nd April to 21st May, that will be 60 days, right? So by 21st May, the proclamation should be passed by both the houses of the parliament with simple majority. Duration, After approval by both the houses of the parliament, it continues for 6 months and it could be renewed, okay, in every 6 months for a maximum period of 3 years. That means it could be renewed a maximum for 6 times. Okay. Then revocation, president proclamation, no parliamentary approval is required for the sake of revocation. It could be just simply revoked by a presidential order. Okay. Effects of president's rule. The president is empowered to administer the state under the president's rule as it dismisses the state council of ministers. So guys, please remember, the government is not dismissed. It is just suspended. The president transfers the state legislature power to the parliament under Article 356, Clause 2. Okay. If any law is to be legislated inside a state where president's rule has been imposed, then the authority is handed to the union parliament to formulate or legislate with regard to that particular state wherever the president's rule has been imposed. So it does not impact the functioning of the high courts as they are independent from the government, and the president can also dissolve a state legislature assembly, state legislative assembly, after parliament's approval of the proclamation, and until then the assembly remains suspended. This is what the Supreme Court has stated in the S.R. Bomai case of 1994. Okay. So the very first state which witnessed president's rule in India was Punjab in the year 1951. And the state with highest number of president's rule is, yes, Manipur, that is 11, including the latest. Okay, 11th time it is. Before that it was 10 and now it is 11, right? So this was the previous news. Moving on to the next news for the day, that is the living will. What is the context? Recently, the Government Medical College Hospital in Kollam, that is Kerala, established a living will information counter. It is the first hospital in India to set up such a counter to popularize the concept of the living will. Now, what is living will and how it is different from euthanasia, or what is even euthanasia? So let's understand. Living will versus euthanasia. What is living will legal in India? Yes, living will is legal in India. Is active euthanasia possible? Active euthanasia is illegal. Only passive euthanasia is allowed. That means if I want to end my life, I cannot end. If I am in the vegetative state, only one of my family members, my parents, my spouse, my siblings, my immediate family only, not even the relatives. My parents and my spouse, in the absence of both, my siblings, immediate siblings, the blood relation, could only provide passive euthanasia. Okay, as the Supreme Court has stated in the Arunima Shanbok case, right? Now, definition. What is living will? A legal document specifying a person's medical treatment preferences if they become incapacitated, that is, medically dead or brain dead. And what is euthanasia? The act of intentionally ending a person's life to relieve from suffering. Effectiveness comes into effect when the person is incapacitated but alive, that is brain dead but alive. And euthanasia requires external intervention to cause death. Outcome does not lead to death but only ensures personal choice in treatment. That is, the person is not given a mercy killing. The person is living but with the choice, that is my will to live. And euthanasia involves medically assisted death, which can be active, okay, that is illegal in India, or passive, that is legal under strict conditions. Okay, so this is what the difference between living will and euthanasia is. Now the next, devolution index ranking of Panchayati Raj system. So we started with the Panchayati Raj system, and we are also here concluding the session, well, with the Panchayati Raj itself. Okay, so devolution index ranking of Panchayati Raj system. What is the context? Karnataka has topped the overall devolution index ranking of the Panchayati Raj system among states in India. Okay, so what is the DI, what is the devolution index, and how Karnataka has topped it? Let's understand. So about devolution index, DI 2024. The report ranks Indian states or UTs based on their devolution. Devolution as is, that is transfer of power and resources. How much decentralization is happening. How easily the powers are transferred and the resources are transferred from one hierarchy to other. Okay, that is what is known as devolution. So who has topped it? It has been topped by Karnataka. Prepared by whom? Prepared by Union Ministry of Panchayati Raj and Indian Institute of Public Administration, IIPA, which is based in New Delhi. So two organizations are involved. Firstly, the Ministry of Panchayati Raj, the Union Ministry of Panchayati Raj, and second, the nodal agency will be Indian Institute of Public Administration, that is based in New Delhi. Next, ranking parameters. What are the parameters that are being followed while creating the report? Overall devolution, framework, functions, finances, functionaries, capacity enhancement, and accountability. Simply, transparency and accountability. These are the two words you can remember. That's it. Top three states. Karnataka with the rank 1, 72.23 of the score, followed by Kerala, 70.59, rank 2, and followed by Tamil Nadu with 68.38, rank 3. Okay. Next, constitutional morality. What is constitutional morality? What is the context? Recently, the concept of constitutional morality has been increasingly used in the Indian judiciary to interpret laws and assess the constitutional validity of the statutes. Okay. It is part of our subject that is known as ethics. Constitutional morality, as in, simply speaking, in one single line, the layman's term, if we follow, that is following the principles of the Constitution, following the preamble at its best, basically. Okay. So, as what we can see here about constitutional morality, so it refers to the guiding values enshrined in the Constitution that must be protected to uphold the integrity and the vision of the Constitution. Basically, everything that is written in the Constitution along with preamble. It goes beyond the legal interpretation to encompass a commitment to values such as sovereignty, social justice, equality, as well as the other factors while having the constitutional adjudication. So, constitutional morality offers a mature form of constitutionalism, balancing respect for Constitution with the ability to challenge and reform it whenever necessary. Constitutional morality also talks about that wherever necessary, please upgrade or amend the Constitution wherever necessary. Just for an example, some 30-40 minutes back, we were discussing about the UCC, Uniform Civil Code, being implemented inside the state of Uttarakhand, though infringing the principles of privacy and Article 21, but still it's needed. So that is what constitutional morality comes in. So this balance prevents a shift towards fundamentalism while allowing for stability and change. And yes, UCC implementation in Uttarakhand is the perfect example of constitutional morality here. So elements of constitutional morality, what they are. What are the elements that are bound to be followed when it comes to constitutional morality? So right to equality, Article 14, due process of law, according to Article 14 and 21, social justice, the whole of fundamental rights and DPSPs, rule of law, once again Article 14, preamble, individual liberty and freedom of expression, Article 19, Clause 1, Subclause A. Right, as we were discussing about with the Right to Information Act as well, right? So this is it with regard to the constitutional morality. And important cases, just please remember the important cases. As we were yesterday discussing with the LGBT community case, Navtej Singh Johar versus Union of India 2018, then Joseph Shine versus Union of India 2018, and the Union of India versus Government of NCT of Delhi 2018. These are the cases which are related to the constitutional morality. Okay, the first one is with regard to the LGBT. The second one is with regard to the section 497, that is the concept of adultery of the IPC. And the third one is with regard to the high-ranking officials must adhere to the constitutional morality and uphold the ideals outlined in the Constitution. That is with regard to the ethical discharge of the function and the duties of the government officials. Okay, so the three cases, what are they? Navteej Singh Johar versus Union of India 2018, then Joseph Shine versus Union of India 2018, and Union of India versus Government of and City of Delhi 2018. Okay, so these are the cases related to the constitutional morality. Next comes into the picture, into the news, that is Article 101, Clause 4. What is the context? Khadur Sahib, an area in Punjab near Amritsar, okay, adjoining area of Amritsar, simply you can call it. Elected MP from there, Amritpal Singh, who has been detained under the National Security Act, NSA, since April 2023, has moved the Punjab and Haryana High Court seeking permission to attend the ongoing parliamentary session. ADC's report. A person who is imprisoned. See the irony. A person who is imprisoned since 2023 has contested the elections, has won the elections, and now appealing to the Punjab High Court, okay, to allow him to attend the parliamentary sessions. A guy will come from the prison, from the jail, and sit inside the assembly, parliamentary assembly, and will legislate the laws for the nation, and will go back to jail again. Irony at its best. Welcome to democracy, right? So why Article 104? So Article 104 states, if for a period of 60 days, a member of either House of Parliament is without permission of the House, absent from all the meetings thereof, the House may declare his seat vacant, according to Article 101, Clause 4. However, the 60-day period does not include the further two things. What are they? Any time when Parliament is prorogued, not in session that is, and any time when Parliament is adjourned for more than 4 consecutive days. So these are the two particular factors. And practical implications, what are they? So the practical implications, as you can see, the 60-day absence is counted only for actual sittings of the Parliament, not when the House is adjourned. And second, this means the calculation of Amritpal's absence is based only on active Parliament sessions, not on the total calendar sessions since its detention. Right? So Amritpal has still options left to come and be the MP. Many of them has these options left. Vacation of seat on account of absence. Even if an MP crosses the mark of 60-day absence, his or her seat will not automatically be vacated. Then how? The House must formally vote to declare his seat vacant. There is a very famous saying in Hindi, chor chor mausere bhai. Here, politician chachere bhai. Okay. Like thief and thief, they are paternal cousins. And politicians and politicians, they are maternal cousins, simply. Right? So, why would anyone make such a resolution, okay, inside the Parliament, until and unless there is a strong political rivalry going on? So, process for seeking leave. What is the process? According to Article 101, Clause 4, it allows MPs to seek permission from the House for prolonged absence, obviously from the Speaker or the Chairperson, in case of Lok Sabha and Rajya Sabha. MPs must submit a request to the Committee on Absence of Members from the sittings of the House, which review the leave applications, recommends approval or rejection to the House. Example, in 2023, BSP, Bahujan Samajwadi Party MP, Atul Rai was granted leave for 23 consecutive sittings due to the incarceration, that is simply imprisonment. Okay. So, when Atul Rai was granted, Amritpal will also be granted. What a big deal. What a big deal. They are only incarcerated. That is, they are only in imprisonment. Only imprisoned. What's the big deal? MPs, they go to jail often. Itna tension nahi hone ka, right? Okay. So moving on to the next topic for the day, that is ex gratia payments. What is the context? Ex gratia as in voluntary payments, basically. Okay. The Ministry of Railways disbursed ex gratia payments in cash to the next of the kin, that is the immediate kins of the victims of the New Delhi stampede, the railway station stampede, raising concerns over the mode of payment. Okay. What we have seen a couple of weeks back, that in New Delhi, many people lost their lives due to the stampede that occurred while people were boarding the train. Okay, just a couple of weeks back. And for this, there has been a news. What is an ex gratia payment? First of all, a payment made out of the moral obligation, not legal liability. First thing. Second, what is the purpose? It shows government's goodwill after tragedies without admitting responsibility of wrongdoing. No strict government guidelines are available on the mode of payment, whether they should be given in cash or a DD or UPI or a check or whatever. Okay, so this time they have been paid through bank transfers. Okay. Now, Supreme Court ruling on gag orders. Next thing. The Supreme Court has granted interim protection from arrest to podcasters and influencer Ranveer Allahabadiya in connection with multiple FIRs registered against him. See, what has happened with the Ranveer Allahabadiya case or the India's Got Latent case, it's not something new. Okay, all of these things happens with such stand-up comedians or the podcasters. But the point is, this time it has taken a severe, cruel turn. And now the question comes into the picture, that is, what are gag, G-A-G, gag orders? So a gag order is a legal directive that prohibits individuals or media outlets from publicly discussing certain matters for the purpose. Okay, what is the purpose? That to protect the fair trial rights, and apart from that, prevents prejudicial media influence. Okay, so that is what is known as gag order. That is a legal directive that prohibits individuals or media outlets. Okay, from what? From publicly discussing certain matters. And what are the matters? It could be any matter. Specifically, the purpose is to protect the fair trial rights, and apart from that, prevents prejudicial media influence. So the Supreme Court's directive bearing Allahabadiya from airing any show on YouTube or any other media platforms amounts to be a gag order. Okay. Is there any legal concept behind judgment? So doctrine of prior restraint. So there is a doctrine. What is the name of the doctrine? Doctrine of prior restraint. That is, okay, you are free to go, but on some certain conditions. That is known as prior restraint doctrine. Okay, so legal basis. Do we have legal basis for this gag orders in India? Okay, yes. Section 144 of the CRPC allows the government to restrict public statements in cases of law and order concerns. Apart from that, Contempt of Court Act of 1971 prohibits public discussion ongoing legal cases to prevent judicial influence. And lastly, Article 19, Clause 2 of the Indian Constitution allows reasonable restrictions on the freedom of speech on the grounds of public safety, security, national security, public order, and morality. Okay, so these are the legal safeguards available to something that is called as gag orders. Okay. Next. Report on global internet shutdowns. According to Access Now, a company, a group, digital rights advocacy group, which is India recorded 84 internet shutdowns in the year 2024. Highest in Kashmir and Manipur. What is the data? Global and national trends on international internet shutdown. India's position globally is second biggest democracy of this globe. Mother of democracy, with second position in global internet shutdowns. India did not have the highest number of shutdowns worldwide for the first time in the last 6 years. Not a matter to be happy. कोई खुश होने वाली बात नहीं है. Okay, decrease from previous year. 2023, India imposed 116 times. 24, 84 times. Congratulations. Okay, so despite this decline, India still leads among democratic countries. Okay, internet shutdowns, and see the countries. Myanmar, obviously, a military coup is going on there since last 4 years. So if there is internet shutdown for the whole of the year, then also it's not a surprise. But India, 84. See, Pakistan, just 21. No doubt people are happier in Pakistan, as according to the World Happiness Index report by UN. Russia, 13. Ukraine, 7. War, in mid of the war, but still 7. Palestine, 6 in mid of the war. Bangladesh in mid of the military coup again, 5. Iraq, always in war, 5. Jordan, 4. And Sudan, South Sudan actually, 4. Also facing civil war. So see, the countries which are in severe conflict, 4, 4, 5, 5, 6, 7, 13, 21. And where we are saying that yes, everything is cool and fine and we are growing, 84. Right? Heartbreaking. Next, origin of the whip system. What is the context? Recently, Vice President Mr. Jagdeep Dhankar criticized the use of party whips, arguing they restrict the MP's freedom of expression and enforce party servility. What is a whip? Simply speaking, your class monitor, not class teacher, class monitor. How a class monitor handles the class students, maintains the discipline, maintains the attendance records, okay, maintains the office keys, the class keys, okay, the access to cupboards and so on, right? It is what given to the class monitor. Simply speaking, maintaining the discipline of the class in the absence of the teacher, right? So this is what the whip does it inside the parliament, okay? So whip is basically a class monitor inside parliament, and this whip is different of every political party. It is neither a constitutional position, neither any political position, neither mentioned in the rules book of the parliament, neither mentioned in the constitution, nowhere. It's just a conventional post, simply just like the school class leader, class monitor. Thus, the class monitor has any reference in the school diary, school prospectus, anywhere? Nowhere. Okay, so just the very same like whip. So origin of the whip system, the term whip originates from the hunting fields of England, where a whipper in would bring straying hounds back into the pack. Okay, that means collecting back the animals. The term was later adopted in politics by Edmund Burke, who referred to it in the context of gathering followers to support the king's ministers. Okay, who was the one who introduced whip from animal husbandry something to politics? Edmund Burke, right? To collect the followers of the king's ministers. So about whip system in India, has been a part of India's parliamentary history since the country's independence, but the post is nowhere mentioned in the rules of the House nor in the Constitution. It owes its origin to the parliamentary convention. So whips are appointed by respective political parties. And what is the function? To ensure the attendance and party line voting. And apart from that, violating a whip, particularly a strict 3-line whip, can lead to the disqualification under the anti-defection law. If you do not follow the orders or the actions of the whip, then an MP could also be subject to the disqualification. Okay. So as what we can see, the Minister of Parliamentary Affairs is the chief whip of the government. Who is considered as the chief whip of the government? The Minister of the Parliamentary Affairs. Now, non-applicability of the whip. There are some cases such as presidential elections where whips cannot direct an MP or MLA on whom to vote. Okay. Types of whips. So 1-line, 2-line and 3-line. 1-line whip informs MPs about a vote but allows abstention. 2-line whip directs MPs to be present but does not instruct on how to be vote. And a 3-line whip requires MPs to be present and vote strictly according to the party line. And this is the most commonly used whip and has the strictest enforcement. So in India, we do have got the 3-line whip. Okay, not 1 or 2. We do follow the 3-line whip system. Okay. Okay, so the next case, the next topic for today. 1.45 lakh pending contempt cases are there in India. Contempt of court, you must be aware with this point. You might have experienced or encountered it in the movies at least, okay, while watching movies. Contempt of court, right? So what is the context? The Union Law and Justice Ministry has asked all ministers to improve the compliance of judicial orders to reduce the number of such cases pending against the government. As we were discussing while talking about the case pendencies in the Indian judiciary, some 5,63,000 data came in front of us. So there we have also discussed that around 50% out of this 5,63 lakhs, okay, 5,63 lakhs was the actual data what we had in front of us. 50% of them is against the government. That is nearly around 2 crores 75 lakhs or 3 crores basically what we can call, right? So the Union Ministry of Law and Justice has asked all the ministers to comply, to improve the compliance of the judicial orders. So what is the logic here about the contempt of the court? The contempt of the court is a legal provision to safeguard judicial institutions from undue attacks and preserve their authority. That is maintaining discipline inside the courtroom. The Constitution of India does not define civil contempt or any kind of the criminal contempt. There is no such definition available. Constitutional and statutory provisions, what are they? The Constitution restricts the freedom of speech under Article 19, Clause 2 to include contempt of court. And Articles 129 and 215 grant the Supreme Court and the High Courts respectively the power to punish for the contempts. And the Contempt of Court Act 1971 provides a statutory basis for contempt proceedings. It was passed on the recommendations made by the H.N. Sanyal Committee. See, constitutionally, there is no definition of contempt of court. There are two types of contempt, civil and criminal. Okay. Does Constitution provides any authority to the Supreme Court and High Courts for the punishment of the contempt? So yes, under Article 129 and 215. Under Article 129 is used by Supreme Court and 215 is used by the High Courts. Okay. To punish in the name of contempt of court. And contempt of court came into the legal presence through the Contempt of Courts Act 1971. And which committee recommended this? Committee ka naam kya tha? What was the name of the committee? H.N. Sanyal Committee. Okay, so please highlight all of these points. Very, very important. H.N. Sanyal Committee, okay, promulgated the Contempt of Courts Act of 1971, article numbers 129 and 215. 129 for Supreme Court, and 15 for the High Courts of the states. Okay, guys. So these are all the points with regard to the contempt of courts. So pending contempt cases, as you can see, in Supreme Court 942, in High Courts 1,44,308. Right, so highest Calcutta High Court, followed by Allahabad High Court, then Andhra, Telangana, Odisha and Madhya Pradesh. So if you see Calcutta High Court with highest 5,262 and Madhya Pradesh being 11,153. So types of contempt of court, okay, there are two, civil contempt and criminal contempt. Civil contempt defined as the intentional disregard of the court orders or breaching a commitment made to the court. Okay, whereas criminal contempt constitutes actions or publications that denigrate the authority of the courts, interfere with the judicial proceedings, or obstruct the justice. Simply speaking, criminal contempt is when you obstruct the justice, that is the procedure of the court. And whereas the civil court is when you intentionally disobey the orders given by the court. So criminal is when you obstruct, civil is when you disobey. Simply, okay. So exceptions, punishment and the 2006 amendment, what are they? So exceptions, fair and objective reporting on judicial proceedings does not constitute contempt. But please understand this thing. It is clearly mentioned. It should be fair and objective reporting. It should not be biased, nor should be fabricated as well. And then constructive constructive criticism of the judicial orders. You should criticize in case if there is an element of criticism, but that criticism should be constructive in nature. It should not be destructive or maligning the image of judiciary. The punishment. Penalties under the Contempt of Court Act 1971 lead to a maximum imprisonment of 6 months and a fine up to rupees 2000 or maybe both of it. Okay, and what are the amendments done to it in the year 2006? Truth and good faith was introduced. What is the truth and good faith? What is that? That is, it valid defense in the contempt cases. Punishment is applicable only if the contemptuous act significantly disrupts the course of justice. Simply speaking, the 2006 amendment stated that the contempt of the court shall be seen only in the case of disruption, okay, and not in the case of willful disobeyment. Okay, so this is what, simply speaking, the cases which related to the contempt of court, right? Okay, guys, so that's it. We have discussed all the topics for the month of February 2025 with regard to the subject of polity and governance in this marathon session. So thank you so much, guys, for watching me for such a quite long time. And I understand you guys might be very retarded. So it's time for us to take a break. So we meet up very soon for the next session for a very important and a hot topic for the day. Okay, but don't worry, it will be not a marathon session. We'll be not much cruel with these things. Okay, we'll give you the appropriate time to relax and ease yourself. Okay, so guys, thank you so much, and please do not forget to like the video, and if you haven't subscribed for the channel, please do subscribe to the channel, and apart from that, provide your valuable feedback into the comment section. Bye bye, see you all soon in the very next one. Take care. Jai Hind.